Hello, everyone. Welcome to another day of LAV's new grantee orientation. We are, as always, excited to have you with us. Just a couple of quick reminders. These are going to sound familiar after the last couple of days, but please feel free to use the chat box at any time to ask questions. The presenters will get to them when they're able throughout the presentation. They might also have some questions for you as you go along, so feel free to answer in the chat. There will be a couple of polls today, like there were yesterday, so keep an eye out for those. And then if you need closed captioning, the instructions are in the chat. I believe that just posted them. So without further ado, there is an awesome team of folks from the Legal Resource Center who are going to present to you this afternoon. So without any further ado, go ahead and take it away.
Thank you. Good afternoon, everyone. I'm Deborah Goldman, the Executive Director of the Legal Resource Center on Violence Against Women. And I'm here today with Maria Vineyard, our Deputy Director, Taylor Duran, our Project Coordinator, and our wonderful law student intern, Emma Ratzman. We are so happy to be here with you. We want to thank the Office on Violence Against Women for supporting our ability to help you with interstate civil legal assistance. And we want to thank the TA to TA project at NCJ-FCJ for hosting this webinar. Most of all, we want to thank each of you, both for spending the time today with us this afternoon, and also for all you do every day representing domestic violence survivors in civil legal proceedings. As you'll see today, or perhaps you've experienced already, these cases involving interstate issues are very complex, and it's incredibly important for survivors to have representation. You probably are seeing some of the same types of cases that we see at the LRC. They generally fall into four different categories. So you may be hearing from clients who want to leave your state or tribal jurisdiction with the children in order to go across the country somewhere safe where they have support. You may be, on the other hand, seeing clients that are coming to you after they've fled to your state and they've come from somewhere else. So you may be trying to help them as an attorney in the refuge state. You also might see cases where clients have conflicting court orders regarding the children. So for example, a judge in a protection order case may have given the survivor temporary custody of the children. And meanwhile, back in the home state, the perpetrator may have gotten a custody order. And finally, you may be working with clients who tell you that the perpetrator is the one who has taken the children across state or tribal lines and failed to return them. We've seen a lot of that during the pandemic, where perpetrators are keeping the children over in another jurisdiction, either in violation of an existing court order or some type of verbal agreement. So any of those types of interstate cases are the kinds of cases that we're happy to assist you with. You'll see in just a few moments what we can do to help, but we encourage you to give us a call. We really have two goals here today. Number one, to share with you how we can support your practice. And number two, to begin to introduce you to some of the complicated legal issues that come up in these sorts of cases. We know that we probably have a range of attorneys on today. There may be some of you that have handled these cases for many years, and there also may be some of you who are quite new. So today is a basic introduction to these sorts of issues, but we do have advanced trainings that will be available soon as well. So first, we'd like to find out a little bit about your experience with these kinds of cases. So we're going to launch a couple of polls and ask you to respond. So the first question is, have domestic violence survivors ever asked you if they can leave your state, tribal lands, or territory with the children to escape from abuse? Thank you. I can see many of you are answering already. Okay, great. I'm going to share the results. It looks like that's a pretty typical question that you're receiving. About 85% of you said yes, that you've seen some of these cases before. Let's look at the second situation, which is whether or not you've ever been in the refuge state. So have you ever worked with a survivor who has come from somewhere else to your state, tribal land, or territory to escape from abuse? And that's with the children. Okay, great. Thank you for sharing. Interesting. This usually has a smaller number of folks, but we've seen about 88% of you have had that experience. So we have seen quite a bit of movement across state and tribal lines throughout the pandemic. Let's take a look at the next question. And that is, have you ever asked a court to exercise jurisdiction over an emergency child custody matter? So again, this might come up typically in the interstate context if you're in the refuge state and someone has fled to your state and you're trying to help a survivor to make that type of argument to the court. Okay, so a fair number of you have had some experience with that, about 41% of you. Okay, and the next question has to do with typically if you're in the home state, have you ever asked a court to decline jurisdiction based on inconvenient forum? And what that means is you are in the state that has preferred jurisdiction and you're making an argument to the judge asking them to transfer a custody case elsewhere. In these sorts of cases, based on safety concerns. Okay, interesting. So we've only got about 29% of you that have made inconvenient form arguments. So I hope that you'll have an introduction to those sorts of issues today. We have worked with many LAV grantees over the years who have successfully made inconvenient form arguments, allowing survivors to remain in a refuge state and litigate child custody there after the home state gives up jurisdiction. All right. Our next question, probably more common now, is have you ever asked a judge to permit your client to testify by telephone or by Zoom or any type of video? And again, this might be a situation where a survivor has fled, is in a refuge state, but the court case is going on back in the home state. All right, and this is quite interesting to us. When we used to ask this question, it was a small percentage of folks who had done that. And now we've got 74% of you have made that type of request from a judge. So clearly becoming much more common throughout the pandemic to have that type of interstate participation in court proceedings. Okay, and one more legal question, and that is, have you ever asked a judge to communicate across state or tribal lines with another judge? This is something that's envisioned by some of these interstate laws. If there are court cases involving a child in two states, in virtually every situation, there's a requirement that the judges communicate. Okay, and it's a smaller percentage than I would have thought, given how many of you have been involved in these interstate hearings. That's just about 36% have made a request to a judge. So it may be that the courts are doing this more frequently on their own now, but you certainly always have that opportunity when you're representing a survivor and something is going on in two states to ask your judge to communicate with the judge in the other forum. And finally, have you ever heard of or have you ever worked with the Legal Resource Center on Violence Against Women previously? Okay, so about 42% of you have, but 58% of you have not. So that means that you're going to be interested in our introduction in just a moment as to how we do this at the LRC. So we're going to perform a little skit for you that shows you how you can contact us. It's a bit aspirational. Everything works out in this particular case, but we're going to give you a sense of how things work. Okay, so Taylor and Emma and Maria are going to unmute and participate.
Good morning, LRC. This is Taylor.
Hi, I'm Nancy Rand, an LAV attorney. I have a question about finding a lawyer for my client.
Okay, well, our organization can assist survivors of domestic violence, sexual assault, or stalking who have interstate custody cases. Is that the situation with your client?
Yes, she actually fled from New York to Pennsylvania after her husband assaulted her a few weeks ago. She'd been working from home due to COVID and the violence was escalating. So now I'm representing her in a protection from abuse order proceeding here in Pennsylvania.
Does she have an attorney in New York?
No, I was told that you'd help her find one.
Well, as the project coordinator, I usually take down some basic information about your request, and then I'll have one of our attorneys look over the facts and call you back later this week. If the case involves jurisdictional issues, we will do our best to help you find an attorney for your client, and we can assist you and the other attorney with understanding the jurisdictional laws.
Okay, that sounds great.
Let me just ask you some basic questions about the case. Does the survivor have children?
Yes, she has 3 children.
Do you believe that your client would qualify for reduced fee services?
Yes, I'm at a legal services organization.
All right. And do you know the county in New York that she came from?
No, she's from Albany, New York.
Okay, I can figure out what county that is. And what county in Pennsylvania are you in?
I'm in Lancaster County.
Were your client and the abuser married?
They are still married and have not yet filed for divorce.
Are there previous protection orders or custody orders?
She had a temporary protection order in New York in December of 2019 when she left previously.
Okay. We are a small organization and have 2 part-time attorneys on staff. Would it be okay if they call you back in the next few days? Or is there a court order coming up immediately?
That should be fine. The protection order hearing is late next week.
Great. I'll just get your name and telephone number and I'll have an attorney call you soon.
Okay, great. My name is Nancy Rand and I'm at Mid-Penn Legal Services, 215-456-7877.
Thank you.
Thank you.
Hi, Deborah. I have a new TA call from an attorney in Pennsylvania. It involves New York and Pennsylvania. Here are my notes. I told her that you'd get back to her shortly. Please let me know if you have any questions.
Okay, Taylor, thank you so much. Are there any pending court dates in either Pennsylvania or New York?
There is a protection order hearing next week in Pennsylvania.
Okay, thank you. Ring, ring. Hello, is Nancy Rand there, please?
Speaking.
Hi, this is Deborah from the LRC giving you a follow-up call. I understand you're assisting a client with an interstate case.
Yes, I'm assisting a domestic violence survivor with a protection order hearing in Pennsylvania. She came from New York with her children.
Okay, do you know if any court orders have been entered by the court in New York?
Not to my knowledge. My client never was served with any papers.
Okay, well, she's going to contact the court in Albany to see whether any pleadings or a complaint have been filed more recently, and then check back in with the court about once a week. We want to make sure that your client knows what's going on back in New York.
All right, well, that makes sense. So I've asked for a temporary custody as part of the protection order. Is that okay?
Yes, that's fine. Pennsylvania has enacted the UCCJEA, that's the Uniform Child Custody, Jurisdiction, and Enforcement Act. And that means that they can get involved on a temporary basis if there's been abuse of a child, or even if the parent has been abused and the child has not been physically abused. Now, from your experience with local judges in your county, is the judge likely to grant a protection from abuse order?
We've had pretty good luck with our local judges in the protection order context, so yes.
Okay, great. Well, keep us posted on how that goes. And if you need any assistance with making an argument that your judge should exercise emergency jurisdiction. Now, with respect to long-term custody, does your client want to stay in Pennsylvania if possible?
Yes, definitely.
Okay, and just to clarify, is it correct that the children have lived in New York up until just a few weeks ago when your client brought them to Pennsylvania?
That's correct. They've been in New York all their lives.
Okay. Well, New York has also enacted the UCCJEA, and under that statute, because of where the children have lived, New York is the children's home state. In fact, right now it's the children's extended home state because they've only been in Pennsylvania for a few weeks. And what that means is that New York gets to hear the long-term custody case.
So how does that work if the Pennsylvania judge issues a custody order in a protection order?
Well, the protection order would fit under emergency jurisdiction, but that's only temporary. And then the law requires the judge that exercised emergency jurisdiction to communicate back with the judge in the home state. And at that point, the purpose of the communication would be to figure out how long that temporary order should last, how to best protect the parties and the children, and also which court is going to exercise jurisdiction over the long-term custody case.
Oh, I see. So what do you think the likelihood is that New York would decline jurisdiction?
Well, I don't practice in New York, but under the UCCJEA, one of the factors that the judge has to consider is whether or not domestic violence occurred and which state can best protect the parties and the children. So that would weigh in favor of New York declining jurisdiction. Also, there's a factor about the relative finances of the parties. And I'm assuming since you're at a legal services program, that your client might also benefit from that factor that might weigh in favor of New York transferring the case as well.
Okay, but that sounds pretty complicated. Can you help?
Sure, we're happy to help. Since there's a jurisdictional issue, we're glad to make some calls on your behalf for your client. And then if we can find an attorney up there in Albany, I can talk with both of you about the case.
Oh, okay, great. Thank you.
And one more thing occurs to me. I don't know if your client is concerned about the criminal consequences of leaving New York with the children. In some states, she could be charged with parental kidnapping.
Yes, she's concerned that her husband may try to get some criminal charges lodged against her.
Okay, well, we do recommend that she speak with an attorney in the home state, both about the parental kidnapping laws and also about the state relocation laws, and we'll try to help make that happen. Also, she may want to contact the National Clearinghouse for the Defense of Battered Women if she does end up being charged criminally.
Okay, thanks. I'll let her know.
Okay,
Bye.
be in touch. Bye-bye. Okay, Taylor. So what do we have in our database for Albany, New York?
It looks like we've got an LAV possibility and the local legal services program. Maybe the New York Coalition or a local DV program would have some other leads.
Great. Hi, this is Deborah calling from the LRC.
Hi, this is Taylor calling from the LRC.
Hi, this is Deborah. I'm calling from the LRC.
Hi, this is Taylor calling from the LRC.
Hi, my name's Penny Dorr, and I'm with the Albany Legal Services Program. I'm returning your call from earlier this week.
Oh, thank you so much for getting back to us. So we're a nonprofit organization, and we try to help attorneys and survivors when there's a need for an attorney in an interstate custody case. We have a case, an LAV attorney contacted us from Pennsylvania, and her client needs representation in Albany. She's in Pennsylvania right now, the client, but New York is the home state.
Oh, great. That's the area we cover. Has anything been filed in New York?
Not that she knows of. If you think you might be able to help with the case, I can try to reach her Pennsylvania attorney right now so we all can talk together.
Sounds great.
Good morning.
Hello, Ms. Rand. This is Deborah again from the LRC. I'm here with Penny Dorr from the Albany Legal Services Program. She might be able to assist your client with the New York part of the case.
Oh, wow, that's great news. My client was served last week after the protection order hearing with a divorce custody complaint. So it would be great to talk to her.
Okay, and what happened at the protection order hearing in Pennsylvania?
Sorry. So the protection order was entered. Her husband filed for custody 2 days later in New York. My client has temporary custody under the Pennsylvania order.
Okay, great. Well, how do you both think it best to proceed?
Well, we'll need to make contact with the client to be sure she's eligible for our services and that there's no conflict, but it sounds like it should work out. Can you send me the documents from New York and Pennsylvania?
Yes, as soon as I get the release. It sounds like you might want to file an inconvenient forum motion in New York.
One thing that we've seen work well in other cases is to file the motions in both states almost simultaneously. So Ms. Rand, you could file a motion in Pennsylvania asking the protection order judge to communicate with the judge up in New York. And meanwhile, Ms. Dorr, you could file a motion in New York asking the New York court to decline jurisdiction.
So I could do that by next Friday. Would that work for your timing up in Albany?
I'll take a look at my calendar and let you know. Now, I've never done one of these motions before. Do you have any samples?
Yes, we have some sample UCC JEA motions and I'll mail them to you. Also, we're glad to take a look at a draft if you would like. Just send us a redacted copy or make sure you have permission from the client to share her information.
That would be really helpful. And Ms. Rand, just have the client call our intake attorney at 516-454-2223.
Great. Thank you so much and good luck, everyone. Bye-bye.
Thank you.
Okay, so that was our skit demonstrating the perfect type of case where the somebody is asking for sample motions. Yes, absolutely. You can request, Taylor's going to talk about what products we have, and you can send us an email at lrc@lrcbaw.org. The email address is at the end of our slides, and we're happy to send you any of our products. But obviously that type of case was a bit ideal. The survivor was represented in both states. Everybody was working together, but that's the kind of thing we hope to see. Thank you very much. So now Taylor is going to give you just a few more details about the organization and how we can support your practice.
Thank you, Deborah. So when should you refer to the LRC? Please feel free to call us or refer survivors to us if the case involved domestic violence. There is a child custody issue, and the case involves more than one state, tribe, or territory. Most cases referred to the LRC are because the survivor is thinking of fleeing the state with children to escape violence or has already fled the state with children to escape abuse. We encourage attorneys, advocates, and others to reach out to us for assistance on these cases. Please note that we do not handle international cases, nor do we directly represent survivors. We can assist survivors in finding civil attorneys when a jurisdictional legal issue is involved. In some instances, a survivor may need a criminal defense attorney and civil attorney. And in that case, we would direct the survivor to the National Clearinghouse for the Defense of Battered Women or another appropriate agency. Our team consists of 2 part-time attorneys and a project coordinator. We are open regular business hours from 8 a.m. to 4 p.m. Eastern Standard Time. And our telephone number is 301-270-1550. At the LRC, we conduct training programs in person and over webinars. We operate a hotline during our business hours, where we talk by phone daily with professionals across the country who have questions on the law involved in interstate cases, including victim advocates, attorneys, and court personnel. We provide attorneys with sample pleadings and case law summaries, and our staff attorneys can help strategize about cases, prepare pleadings, and conduct legal research. Additionally, we provide advocates with legal information and referrals. And for survivors who call us when there is a jurisdictional question, we can help find an attorney using our database of attorneys and programs across the country. In terms of written resources, we maintain a website with jurisdictional and related laws that anyone can access. You'll see here a list of tools we've developed over the years for attorneys, advocates, judges, court personnel, and survivors that span across disciplines to ensure that this important legal information is meeting those who need it most. The relocation checklist for attorneys and advocates assists professionals with understanding the types of questions to ask survivors with interstate cases. The relocation guide for survivors is available in both English and Spanish, forthcoming in Chinese and French. You may wish to share this document with your clients. We have drafted 150 recent UCC JEA case law summaries available by topic. We also have a UCC JEA judicial article and guide for judges that you can share with your local judges, a brief bank which includes sample pleadings, and an interstate cooperation guide for attorneys. On womenslaw.com, you can find a video on interstate custody and domestic violence in both English and Spanish. And finally, forthcoming is a sample intake form for relocation cases. If interested in receiving any of these documents, please feel free to email the LRC or contact our office directly. Our upcoming trainings include the Basic Interstate Custody Institute. This is a two-part intensive webinar where attorneys will have an opportunity to make mock arguments and play a Jeopardy game. You can visit our website to find the registration link for this webinar series. I will now pass it back over to Deborah.
Thanks so much, Taylor. So now we're going to turn to a bit of legal information, and we're going to start with what is probably the most common question that you all might get from clients as LAV attorneys, and that is, can survivors actually leave the state with their children? The answer is a resounding maybe. It depends both on the facts of the case and what the laws are in the original state. In particular, what does a parental kidnapping law say in your state? And what does the relocation law say in your state? Ideally, survivors should connect with a knowledgeable attorney before leaving the state. And sometimes that can happen with the survivor taking the children, going into a shelter, or staying in a safe place within the state, just in order to have the time and privacy to connect with an attorney before making the very important decision about whether or not to relocate with the children. Next slide, please. So some of the main issues that you as attorneys will be exploring with your clients are the following. Is there an existing court order already? Where is the custody case going to take place for the child? In 49 out of 50 states, that's going to be answered by the UCC JEA. Also, what does a state relocation law say? And what does a state parental kidnapping law say? Next slide, please. So we're going to illustrate this type of case with a case scenario. Taylor's going to share the facts with you.
Lila Smith calls you at your office in Nashville. You learn that Lila and Philip have been married for 5 years and have lived in Nashville throughout the marriage. They have one child, a 7-month-old daughter named Annie. Philip has physically and emotionally abused Lila since shortly after they were married. Philip has never been charged or convicted criminally for the abuse, and Lila has never sought a civil protection order against him. Lila thinks a neighbor may have heard the abuse, including the most recent incident, which took place last week. During that incident, Philip held a gun to her head in front of Annie and threatened to kill her. Lila tells you that she wants to leave Nashville and move to California, where her family lives and where she hopes to find a job.
Thank you, Taylor. So as you can see, that's a pretty typical fact pattern. There's some serious domestic violence that has been perpetrated, but there has not been a lot of involvement in the past by either the criminal justice system or by the civil justice system. So there's no prior convictions, there's no prior protection orders. You may encounter these cases pretty frequently in your work. So we're just going to start exploring some of the legal issues that this type of case can bring up. And please feel free to comment in the chat, those of you who have experience with these kinds of cases. And also please feel free to ask any questions in the chat as we go along. Next slide, please. So one of the first questions that you want to find out from your client is, has a custody order been entered previously? In our fact pattern, neither Lila nor Philip have ever gone to court before seeking custody of Annie. But with your real cases, you will find that many of your clients might already have some type of custody order from the past. It might be a custody provision that's part of a protection order, or it might be a long-term custody order under the domestic relations laws in one state or another. The reason that matters is you don't want your client to violate any portion of a custody or visitation order by leaving the state with children. So whether your client has primary physical custody, if there's some visitation that's been given to the perpetrator, you want to try and get a court order modified before your client leaves the state, just so that your client is not exposed to contempt for failure to comply with provisions in a custody or visitation order. Another legal issue that does come up in these cases is the criminal laws in whatever state the survivor is thinking of leaving. So in Lila's case, this would be the state parental kidnapping, or sometimes called custodial interference laws in the state of Tennessee. In some states, it would be perfectly fine for someone like Lila to leave the state with the children. But in other states, there may be stricter parental kidnapping laws. We know that you all are civil attorneys, not criminal attorneys, but since you're working with survivors in these kinds of cases, it's critical for you to familiarize yourselves with what the state parental kidnapping law says in your state. If you need help finding that out, feel free to contact us as well. Another prior slide, please. Oh, that's good. Another type of law that comes up is what's called a state relocation law. For some of you, your state relocation laws are going to be easy to find. They're labeled, they're a separate statute, they're called relocation law. In other states, your state relocation law may be one little provision that's tacked on to your generic custody law, your best interests of the child custody law. And in still other states, there might be nothing in your statutory codes about relocation, but there might be relocation standards that have been established by judges in prior relocation cases. You can get started looking for your state relocation laws on our website. We do have the statutory laws listed there. And if you need help with any type of research, we're happy to do that as well. But we do suggest that all of you LAV attorneys also familiarize yourselves with your state relocation laws so you can give appropriate legal advice to survivors with these kinds of cases. Additionally, there may be a variety of other legal issues to consider. For example, if your client has an issue with immigration status and perhaps might be applying for a U visa or a T visa or a self-petition under the Federal Violence Against Women Act, that can also raise some issues around relocation. Similarly, maybe your client has a lease for an apartment and is thinking about breaking the lease in order to move. So you may have that type of legal issue. You may be thinking about child support on behalf of your client and wondering where to file. Your client may be thinking about removing the children from school and facing some sort of child truancy issues. So all of this is to say that interstate cases and cases involving relocation really cover a whole wide range of legal issues. Next slide, please. We're addressing some of the most common issues here today. And one of those is, should someone like Lila file for a protection order before leaving the state? I encourage you to share your experience in the chat if you've worked with clients with that situation, and we'll examine that in just a moment. If Lila doesn't get a protection order in Tennessee, is Lila going to be allowed to get a protection order in the new state of California? There might be a few different legal hurdles there, one of which is called personal jurisdiction. What that means is, can the court in California reach out over Philip way back in the state of Tennessee and order Philip to do something like stay away from Lila? And that is really determined by whether or not Philip has had minimum contacts with the state of California. So just as an introduction, your client might bump up against a personal jurisdiction problem if she waits until she gets to California to file for a protection order. And Monica, thank you for asking that question in the chat. She has asked, what if they order visitation in the protection order and she cannot leave? That is a huge issue, and you'll see that pop up in just a moment on one of our slides. And of course, if visitation is granted to Philip on alternate weekends and Wednesday evenings, and that's part of the protection order, that's going to make it all the harder for someone like Lila to leave the state. So you really have to weigh that issue of whether or not it makes sense to help your client get a protection order before leaving the state. And we'll get back to that in just a moment. But some of the other broader legal issues are, what about child custody jurisdiction? Is the UCCJEA going to require Lila to bring Annie back to the original state? And by the way, it's not just the UCCJEA. If you've got cases involving tribal jurisdiction, every tribe is a sovereign nation and has its own child custody jurisdiction law. So those may be involved. There are also a couple of states and territories that haven't enacted the UCCJEA. So in those cases, they may fall back on a federal law called the PKPA or an earlier version of the uniform law called the UCCJEA. When we see judges in these kinds of cases, let's just assume that Lila left and Philip filed in Tennessee right afterwards for custody there. We see judges doing a couple of things. There are certainly a handful of cases where a judge in the civil context will order a child to be brought back. And that's certainly very difficult in these cases involving severe violence. But we also see a lot of cases where judges are permitting the survivor and the child to remain in the new state, the refuge state, and somehow to participate in the court proceedings back in the original state. So maybe they have to come back for those court dates, or maybe, especially increasingly now, they can participate by Zoom and still remain in the refuge state of California while participating in a court proceeding that's happening virtually in Tennessee. And finally, somewhat of a best case scenario, if Lila is lucky enough to be able to be represented by an LAV attorney in Tennessee, and that attorney makes a good argument for inconvenient forum, it may be that a judge in Tennessee will transfer the whole custody case over to California. And sometimes that can be quite helpful. Finally, the last legal issue on our slide is called continuing exclusive jurisdiction. It's a bit of a mouthful, but what it means is that a court that entered a child custody order gets to modify its own order as long as one parent still remains in the state. So let's say that Tennessee did enter a custody order on behalf of Lila, and then Lila left following all the rules and went to California. If that custody order needs to be modified, it will have to be modified in Tennessee, unless Philip moves out of the state or the judge in Tennessee decides to transfer the court case. So that's just a brief introduction to some of the more complicated legal issues that come up in these interstate cases. Now we're going to turn to some of the specifics. Next slide, please. And one more slide as well. So here comes the question that Monica was asking about, which is filing for a protection order in the original state before leaving. Just like any domestic violence case, there are many benefits to helping a client get a protection order in the original state, as long as the client thinks that that's going to be helpful and will protect them. So first of all, protection orders generally decrease the violence on part of perpetrators. For most perpetrators who will comply with the court order and will stop being physically violent while there's a protection order in effect. Also, under the Federal Violence Against Women Act, a protection order that's entered in Tennessee is going to be enforceable all over the country. So if Lila ends up moving to California, California police, California courts will have to enforce a protection order out of Tennessee. Second, in a case like Lila's, there's very little documentation right now of the domestic violence. And as many of you know, domestic violence can show up in many different legal statutes, and there are many protections for survivors. But the legal protections are only helpful if a judge is going to believe your client's credibility, and the judge is going to understand that domestic violence has been perpetrated. So getting a protection order at this point in time might help someone like Lila down the road. It might help her with a custody case when the courts are required to consider a history of violence. It might help her in a jurisdictional case. You're going to hear about some arguments that can be made under the UCCJEA, but those judges also have to believe that there's been a history of violence. It might help her in immigration cases. So for all those reasons, getting a protection order, especially if it's an order that's been contested and there's a finding of domestic violence, that can be really helpful to your client down the road. Additionally, if there's no protection order in place and Philip does what many perpetrators do and says, well, you can leave me, but I'm going to keep the children, or actually shows up and takes Annie physically from Lila once they've separated, the police are not going to be able to return the child to Lila unless there's a court order in place. So getting temporary custody as part of a protection order can help Lila protect Annie and get Annie back if Philip does try and take her. And finally, the last point is just California may not be able to enter a protection order later for a number of legal reasons. So those are all benefits to filing for a protection order. Now let's take a look at some of the risks, including the one that Monica identified for us a few moments ago. And that is number one. If someone like Philip is awarded visitation, the survivor will need to comply with that, and that might make it impossible for her to leave the state. So that's something to think about that doesn't typically come up when you're in a non-interstate type of domestic violence case. You don't need to worry about that. But if your client is thinking about relocating, you don't want to make it harder for them to relocate by having a visitation order in place. Additionally, once you have custody that's been entered as part of a protection order, it can create a type of domino effect, and it can start triggering other laws that otherwise might not be involved. So for example, if you represent Lila and you get her a protection order and temporary custody of the child, in some states, your state parental kidnapping law and your state relocation laws might only be triggered after there has been a custody order entered. So if you are thinking you're helping Lila, you're getting her a protection order, and all of a sudden there's a custody order on the books, that might then involve the parental kidnapping law and the state relocation law. And again, it does vary depending on what state you're in and what the state laws say, but it can make your client's legal situation much more complicated. Similarly, because of what we mentioned a few moments ago with continuing exclusive jurisdiction, if you get a custody provision as part of a protection order, that might then mean, at least while the protection order is in effect, that the state where you got the protection order has continuing jurisdiction over that custody order. So again, you're just trapping your client a little bit into further litigation in the original state. And finally, the last risk that we mentioned may be a small point, but Maria is going to talk with you in a few minutes about the UCCJEA's recipe for making an inconvenient forum argument. And you'll see that one of the 8 factors that a judge has to consider is there a state that's already familiar with this family, with these legal issues? So if you have helped your client to get a protection order, that actually might weigh in favor of Tennessee down the road, keeping the long-term custody case because they've already invested some judicial resources in this particular family. So as you can see, there's no easy answer about getting a protection order for your client who wants to leave the state. There are a lot of different items to weigh, and we're happy to help you if you have a case where you're considering that. Next slide, please. Now I'm going to turn it over to Maria just to very briefly introduce you to some of the federal laws and some other laws that may be involved in these cases.
Thank you, Deborah. So you can see a few of the federal laws that are relevant here on this slide. The first one on the list is the VAWA Violence Against Women Act. The reason we mention this law is because of a provision within it which requires that a protection order that has been entered by one state, tribe, or territory be enforced in any other state, tribe, or territory. So custody provisions that are part of a protection order would also be enforced across state lines. The second law on the list is the Parental Kidnapping Prevention Act, the PKPA. So really this law has nothing to do with parental kidnapping, even though that's in its name, but it has to do with honoring and enforcing custody orders from other states. So for example, in Lila's case, if she obtained a custody order in Tennessee before she moved to California, this law would require California to honor and enforce the custody order from Tennessee. The third law on the list is the Indian Child Welfare Act, or ICWA. This law was passed in 1978. The fate of this law is currently being considered by the Supreme Court. It was originally meant to protect safety and security of Native American families and their children. Congress passed the law because children were being removed from their tribes without much of a basis. The law states that certain types of child custody proceedings, there must be a minimum federal standards for removal of the children from their tribe, and that the tribe has exclusive jurisdiction over certain matters. The types of cases that are usually involved here are not the typical protection order or custody cases between two biological parents. This law applies when the state becomes involved. So it's foster care cases, adoption cases, and termination of parental rights. The last law on the list is the International Parental Kidnapping Crime Act. This law does involve parental kidnapping and taking a child from the US to another country. There is a defense to this law when a parent is fleeing to another country with their child because of a domestic violence incident. Next slide, please. So here are the relevant, some of the relevant state and tribal laws. So UCCJA, custody laws, we will discuss further on in the presentation in more detail. In terms of tribal custody and jurisdictional laws, because every tribe is a sovereign nation, it is important to know that they might have their own tribal codes. And within that code, there might be a child custody jurisdictional law that is separate from the UCCJA. Tribes as well as states have also enacted their own full faith and credit laws that have to do with enforcing protection orders from other jurisdictions. Under tribal and state full faith and credit laws, there may be details about how you go about enforcing protection orders from other places. States also have separate protection order laws, relocation laws, and parental kidnapping laws, which are also important to understand in assisting domestic violence survivors. But we'll go over these last few laws in more detail in the rest of our presentation. So I'll pass it back to Taylor.
Thank you, Maria. So what safety, economic, and legal issues does Lila need to consider? There are many issues to consider as a survivor is thinking about relocation. Questions to think about may include, what is the survivor's relationship to the refuge state? Will they be safer there? Do they have support structures in place for emotional support and getting basic needs met? Do they know how they are getting to the refuge state? Is the car in the survivor's name or in the abuser's name? What should the survivor bring with them? Important documents, prescription, identification, birth certificates, social security cards, immigration paperwork if they have it? And how about tech safety considerations? Are they on the same phone plan? Does the abuser have access to any of the survivor's email or bank accounts? Survivors know their situations best and are often forced to make these very difficult decisions while navigating the daily reality of living with trauma and abuse. We want to assist survivors with setting them up for success wherever they will go, while not undermining their autonomy and decision-making. There are many decisions to weigh, and it can be helpful to have the survivor work with an advocate in the refuge state and in the home state to help address the safety and economic issues that come up for domestic violence survivors trying to flee. I'm now going to pass it back over to Deborah.
Thank you, Taylor. So now we're going to dive into one of our favorite laws, the UCCJEA. Could you reverse one slide, please? And the UCCJEA is a uniform law. What that means is that a commission of uniform state commissioners, uniform law commissioners, got together and decided to develop a law that then would be adopted across the country by different states. The UCCJEA itself was developed in 1997, and it was designed to fix some of the problems that had come about with the former version of the law, the UCCJA. The former version of the law allowed more than one state to get involved in a custody matter over the same child. So it didn't really solve the problem of conflicting court orders because two states could be right under the former version of the law. Under the current version of the law, there's a hierarchy, which you'll see in a moment, prioritizing the home state. And that means that when there is a home state, the home state is the place that gets to hear the custody order. The UCCJEA was also meant to bring uniform state laws to make them consistent with the federal PKPA, which already had prioritized the home state. And as you can see, all 49 states except for Massachusetts have enacted the UCCJEA, and also DC and Guam and the Virgin Islands. If you have a case or if you're practicing in Puerto Rico, it's the PKPA that applies. And if you practice in Massachusetts, it's the UCCJA. On our end, we view the UCCJEA as a benefit to domestic violence survivors. The uniform law was developed with input from folks in the anti-violence movement, and there are some provisions that very explicitly describe domestic violence and give you all, as LAV attorneys, the opportunity to make some excellent arguments preserving the safety of your clients. Next slide, please. So you can see the map here. One more slide, please. So now we're going to take a look under the UCCJEA at Lila's situation. So we're going to examine 5 different questions. First, can Lila get a custody order in Tennessee? Next, can she get a custody order in Tennessee in California if she leaves Tennessee? Third, what if she has to go back to Tennessee to litigate? And fourth, what about parental kidnapping? And fifth, is it even legal for her to leave the state with her children? Next slide, please. So can Lila get a custody order in Tennessee? Let's use the chat to see what you all think. Do you think that Lila can get a custody order in Tennessee? Remember, Annie is 7 months old and she has lived that whole time in Tennessee. Please feel free to answer in the chat. I'm seeing a lot of yeses. Very good. You guys are all correct. Next slide, please. And the reason is Tennessee has jurisdiction. Tennessee is actually Annie's home state. Next slide, please. So we're going to show you a visual that presents the different jurisdictional bases under the UCCJEA. And at the top of our ladder, you can see the home state or the 6-month rule. What that says is that if the child has lived in a state for at least 6 months with a parent or a person acting as a parent, that is the home state, and that state has priority over any other state in terms of exercising jurisdiction. If there is no home state, if the child hasn't lived somewhere for 6 consecutive months, then you look at the second rung of the ladder, or significant connection jurisdiction. And just like it sounds, that enables courts to take a look and see whether or not their state has a significant connection with the family. Is there substantial evidence in that state about the child and the child's care and protection and trainings? The third rung of the ladder is a little bit different. More appropriate forum means that a judge that had jurisdiction somewhere else, usually the home state, decided to give the custody case up in favor of a more appropriate forum. And in just a few moments, Maria will share with you how you all can be helpful in making these kinds of arguments when there's been a history of domestic violence. But for now, the final rung of the ladder, no other state, is sometimes also called vacuum jurisdiction or jurisdiction of last resort. It covers a fact pattern where the family has moved around so much that there is no home state, there is no state with a significant connection, and nobody has given up jurisdiction in favor of a more appropriate forum. So for example, we once helped with a case where the family traveled every couple of weeks living in an RV. So 2 weeks in one place, 3 weeks in another, a month somewhere else. That might be a situation where a judge could exercise vacuum jurisdiction. Next slide, please. So just to flesh out a little bit more the home state rule, one of the things that you will see most often in domestic violence cases is something called the extended home state rule. And what that means is that let's use Lila as an example. Let's say that Lila leaves today with Annie and moves to California. Philip has a window of 6 months after the child is removed. And during that 6-month window, he can still file in Tennessee because of Tennessee being the extended home state. So for many survivors, if you're in a refuge state and a survivor has fled to your state, you need to advise them to check back in with the courts in the original state for at least 6 months, just to see if the left behind perpetrator has filed for custody there, because that original state will still have jurisdiction over the matter. So that's the extended home state rule. There's also a bit of a nuance for children who are less than 6 months old because they haven't lived anywhere for 6 months. Let's say you have a child who's 5 months old but has lived in Tennessee the whole time. The UCCJEA says that for children less than 6 months old, the home state is the state where the child lived from birth. So it would still be Tennessee. And finally, another issue that comes up frequently that you may end up litigating is this concept of temporary absence. What it says is that if you've got a home state and the child has a temporary absence from the home state, that doesn't deprive the home state of its status as the home state. So to give you an example, if Annie visited with her extended family in California last summer for 2 weeks, that doesn't take away from Tennessee being the home state as long as she returned. And so that's a simple example, but these temporary absence cases can often be more complex. So for example, if you're working with military families, it may be that the military member has been stationed somewhere and the family has gone with. And there's often litigation over whether or not a particular time period was a temporary absence or was it actually a permanent relocation? There's no specific time period within the UCCJEA that gives you the answer in every situation. So we do have case law on temporary absence, and we're happy to try and help you make arguments that will benefit your clients. Next slide, please. So you already knew this. The answer is yes, Tennessee is the home state. Next slide, please. And now just a little bit more to flesh out significant connection jurisdiction. So again, recall that judges no longer have to consider, is there a state with a significant connection if there's already a home state? So this is only when there is no home state. And these cases can be a little bit more complex because it's the one factual situation where it does matter who files first in the courthouse. So consider this type of fact pattern. Let's say that Annie has lived for 4 months in Tennessee and 3 months in Oklahoma. So there's no home state. It's 4 months in one state, 3 months in another. At that point, there could actually be 2 different states that have a significant connection to the family. And so then it does matter which parent files first, because once one parent has filed in a significant connection state, if the second parent comes along and files in a different significant connection state, that second state has to put the brakes on. They cannot get involved. So what are judges looking for when they're trying to figure out if a state has a significant connection with a child or a family? The kinds of factual things that they're exploring are things like, does a child have relatives in the state? Has the child been in daycare or school in the state? Does a child have a pediatrician or a doctor or dentist in that state? What about the parents? Have the parents changed their driver's license to that state? Do the parents still own a home back in a different state? Where is their lease? Where are the parents paying taxes or getting public benefits? Those are the kinds of factual items that judges are looking at and the types of evidence that you will want to accumulate to make significant connection arguments. And again, we do have some case law on significant connection, and we're happy to share that with you as well. Next slide, please. So now we're going to consider on the flip side, you've all agreed that Tennessee has jurisdiction as the home state, but what if Lila flees to California? Is there anything that Lila can do in California to get the California judge to exercise, to hear a custody matter? Maria is going to share that with you.
So to start off, I'd like everybody to also put in the chat whether or not they think that Lila can get a custody order in California after she flees there. So please put your answer in the chat. Great, yeah. Wow, I see that most of you are very well informed. Most of the times when we present this, we get a mix, but I see most of you are saying yes, and that is correct. So next slide, please. So while it's true that California does not have long-term jurisdiction, it could exercise temporary emergency jurisdiction, as most of you said in the chat. So by the way, we do find a lot of clerks, judges, and attorneys do not know this. So congratulations on knowing this already. It is important to understand that the UCC does include temporary emergency jurisdiction as an option, even if the child has not lived in the state for 6 months. So this is the third rung on the ladder that actually, no, it's in addition to the jurisdictional bases that Deborah has just discussed. So under the UCCJEA, courts can exercise temporary emergency jurisdiction when necessary in an emergency to protect the child because the child or a sibling or parent of the child is subjected to or threatened with mistreatment or abuse. So the underlying language here represents an improvement over the old version of the law, the UCCJA, because it grants the court the power to issue an emergency custody order in domestic violence cases where the parent, but not the child, has been abused. So please note that emergency custody only helps if the child is physically present in the refuge state. It will not help if the parent flees over the state lines and is trying to gain custody without the child. But even if the parent has fled over state lines with the child, attorneys and advocates often wonder whether they should encourage a survivor to file for emergency custody. So we'd recommend considering with the survivor whether or not there's a risk that the perpetrator is likely to show up and try to take the kids. If this is the case, then we would seriously consider filing for emergency custody. If the risk is not great, then the survivor will also want to consider the risk that filing in the refuge state will probably motivate the perpetrator to initiate a custody filing back in the home state. Next slide, please. So what does temporary mean? Is it months, years? So what constitutes temporary custody varies by state and by the facts of the case. There is no specificity in the UCCJEA on how long the temporary order should last. However, under the UCCJEA, the length of the order is supposed to be determined by judicial communication. So if Lila files for temporary emergency custody in California, and meanwhile Philip has already filed for custody in Tennessee, then Lila is obligated to inform the California court of the proceedings in Tennessee. The court in California is required under the statute to communicate with Tennessee, the home state. This is important because the California court could inform the court in Tennessee of the domestic violence that has occurred, and that would be also involved in determining how long the temporary would be. Next slide. So what if Lila would like to obtain a protection order in California over Philip? If Lila is going to file for a protection order in the refuge state, there are a couple of legal issues to consider. One of these, Deborah mentioned earlier, is personal jurisdiction. So in most states, the judge has to consider whether or not the state has personal jurisdiction over the respondent before entering a protection order. So it has to be fair for the judge to get involved. Next slide, please. Personal jurisdiction turns really on whether or not the perpetrator has had minimum contacts with the state that is entering the protection order. So in the case of Lila, if Philip has never been to California before, is not stalking or monitoring Lila in California, then California will probably not have personal jurisdiction over Philip. On the other hand, if Philip has business dealings in California, has been to California previously, is calling Lila in California and threatening her, that might be enough for a California judge to have personal jurisdiction over Philip. Each state does have its own laws about personal jurisdiction, But we have recently seen that in some states, courts are expanding their definition of personal jurisdiction and considering threatening or harassing text messages, social media postings, emails as sufficient to have personal jurisdiction over the perpetrator. Please feel free to call us at the LRC if you do have questions about personal jurisdiction. Next slide, please. So generally speaking, Lila will not be able to obtain long-term jurisdiction in California unless Tennessee decides to give up jurisdiction and transfer the case to California based on inconvenient forum. So the decision to decline jurisdiction would be made by the home state judge. So in Lila's case, it would be made by the judge in Tennessee. The UCCJEA lays out 8 mandatory factors that the judge in the home state must look at in deciding whether or not to give up jurisdiction and transfer the case to the refuge state. Next slide, please. So here is the list of 8 mandatory factors that a judge must consider in evaluating whether or not to give up jurisdiction. The first factor on the list is whether or not domestic violence has occurred and which state could best protect the parties and the children. This shows that the drafters of the UCCJEA understood that when domestic violence was prompting a survivor to flee from one state to another with the children, that there should be a way for survivors to transfer the custody case to the state where she took refuge. This is why it is so important to have documentation of the abuse, including prior police reports, protection orders, convictions, etc. Judges are more likely to transfer the case if there is documentation of the violence. The fourth factor on the list considers the relative finances of the party and which party has more money and can afford to travel between the courts. And it may be relevant also in cases where the survivors do not have access to their family's finances. The 8th factor on the list asks the judge to consider which state is more familiar with the issues and the parties involved. So if a state has already been involved in the family's life in terms of issuing protection orders or with child protective services, that could weigh in favor of the home state keeping the case. Now I'm going to turn it over to Taylor.
Thank you, Maria. So what if Lila is required to return to Tennessee to litigate the custody case after having relocated safely to California? In this case, an attorney for Lila can request that she be permitted to participate by telephone or video in court hearings. A judge can also request interstate cooperation from the refuge state. And advocates can also help Lila find safe shelter and court accompaniment in the home state. I'll now pass it back over to Deborah.
Thank you both. So we've been going for a while. We want to give you all a break. We're going to take a break for 10 minutes. I'm on the East Coast, so it's 2:07 here. We'll start up again at 2:17. Relax, maybe get a snack, because when you come back, we're going to look at some case scenarios applying the UCCJEA and ask you to really think through some actual fact patterns that you may have seen and we have certainly seen. So we'll see you all in 10 minutes. Thank you. All right, welcome back, everyone. So please feel free to turn your cameras on at this point. We're hoping to have a bit of a discussion, and you can also answer in the chat if you feel more comfortable that way. But we're going to go ahead and we're going to try to apply the UCCJEA to a couple of fact patterns next. Next slide, please. Okay, so we will read the question out to you, and then you can answer which state has jurisdiction and why you think so. And I will say that question number 1 is a tough one. So It's going to get easier from here on out. But first question, Sylvia obtains a protection from abuse order in Pennsylvania and permission to move to Arkansas with her daughter, Jess. Jess's father, Hank, still lives in Pennsylvania. He repeatedly harasses and threatens Sylvia when he visits with Jess in Arkansas. Sylvia would like to ask a court in Arkansas to modify the order and hold a virtual hearing. So think about it for a few minutes, and then you can write into the chat or feel free to unmute and we can talk as if we're in a room together. Okay, so we've got a couple of Arkansas and one Pennsylvania. Monica says you have to get permission from Pennsylvania to give up jurisdiction. Okay, you're asking how long they've been in Arkansas. Interesting question. So let's say they've been in Arkansas for 7 months. Does that matter? Because the dad is still living in Pennsylvania. I'll answer that question. It doesn't matter. The dad is still living in Pennsylvania. Pennsylvania is still going to be involved. Okay, Pennsylvania till they give up jurisdiction. A lot of folks are answering in the chat. Order is enforceable in Arkansas. Pennsylvania. Okay, I'm just going to read out the comments so that everybody can see what other folks are thinking. So it is true, the comment from Kimberly, that the order is enforceable in Arkansas. It's true that it's enforceable there, but we're talking about modifying the order. That might be a little bit more complicated. Sonia has said Pennsylvania until they give up jurisdiction. That is true. Pennsylvania has continuing jurisdiction. So Arkansas cannot wrest jurisdiction away from Pennsylvania while dad is still living in Pennsylvania. Pennsylvania has continuing jurisdiction, and that's what Brooke is saying. Pennsylvania has continuing and exclusive jurisdiction as long as one parent lives there, but she might be able to make an inconvenient forum argument. Okay, and then we have a comment that Arkansas could get involved. So let me explain, since this fact pattern is a little bit complicated. And also I didn't mention that we're assuming that the protection from abuse order is still in effect and that custody provision within the PFA is still in effect. So if that is the case, that means that Pennsylvania is the only state that can modify its own custody order. And Pennsylvania has continuing jurisdiction because one of the parents still lives there. The only thing that Arkansas could conceivably do is to get involved on an emergency jurisdiction basis. So just like any other type of emergency scenario, if a judge in Arkansas believed that this type of harassment was an emergency, then the judge in Arkansas could get involved on a temporary basis and enter a temporary order. Then, of course, there would then be the requirement that the judge in Arkansas communicate with the judge in Pennsylvania. And I see Caitlin has said it could also depend on whether Pennsylvania's protection order actually creates continuing exclusive jurisdiction. Now, that's a really interesting question. And Caitlin saying in Texas, a protection order does not create continuing exclusive jurisdiction, even if it includes custody and visitation orders. I'd love to talk to you about that, Caitlin. That's really interesting if there's been a ruling by a court in Texas finding that. What we have found in most cases is that for the duration of a protection order, if there's a custody provision in it, and if it was entered by the court that had jurisdiction, like the home state court, then it does typically give continuing exclusive jurisdiction while the order is in effect. But there are a lot of court cases out there that say once the protection order has expired, it's not a separate basis for creating continuing jurisdiction in the state that entered the protection order. So apologies, the first question was a bit complicated, but you guys did great. Let's move on to question number 2. Next slide, please. Okay, Millie has recently fled to Indiana with her 2-year-old daughter from Louisiana, where she lived, the daughter and Millie, for 5 years with her husband, Dan. She was afraid to stay in a shelter because of COVID and traveled to stay with her sister in Indiana instead. She has been in Indiana for a month. Last week, Dan filed for custody in Louisiana. So think about this one, and thank you for putting your answers into the chat. You can feel free to explain why. If a whole bunch of people are saying Louisiana, why are you guys saying Louisiana? And explain yourself in the chat, or you can unmute yourself. You're saying the child hasn't been in Indiana for 6 months yet. Yeah. Okay. So we've got a couple of people adding some additional ideas. Great job. Okay, so just going to go back, try to make sure that everybody's seeing what's in the chat. So basically, many of you have said Louisiana because of the extended home state rule, right? We talked about how if a child leaves a home state, there's a window of 6 months after the child is removed when that home state is called the extended home state. And somebody can file in that state and they have preferred jurisdiction. But we've also got a couple of folks giving the idea that there might be temporary relief appropriate in the state of Indiana. So that's absolutely right. Even though she's only been in Indiana for a month, conceivably, if she needs it, she could ask a court in Indiana to exercise emergency jurisdiction. And the facts, we don't know yet. Is it that essential for a court in the refuge state to exercise emergency jurisdiction? Maybe. It seems like there was some history of domestic violence and she was considering staying in a shelter. But if Indiana got involved, they could only do it on an emergency jurisdiction basis, and it could only be a temporary order. So unfortunately, Dan is in the right state. And this is just highlighting why a survivor needs to be checking back with the original state to make sure they know about any custody proceedings. We do see a lot of cases where the left behind perpetrator files in the home state, maybe doesn't serve the survivor with actual service and is permitted to proceed by the judge, maybe by alternative service or publication. And then the judge in the original state sometimes ends up entering an order giving the perpetrator custody of the child because they haven't heard anything from the survivor who's in the new state and unaware of these proceedings that have gone on. So please make sure if you're in a refuge state, talking to a client, that you're helping them find out what's going on back in the extended home state. Okay, great job. Let's take a look at another fact pattern. Next slide, please. Okay, to punish Maria for calling the police after he assaulted her, Brian took their 5-year-old son from Texas to Oklahoma in November. Before that, the family had lived in Texas together since the child's birth. Brian has not permitted Maria to visit or talk with the child. There's no custody order in place. So what do folks think? Which state has jurisdiction with this fact pattern and why? It's a little bit different. It's the perpetrator who has taken the child across state lines. A couple folks have answered that Texas is the home state. Texas is the home state. Okay. Make sure I didn't miss anyone here. Okay, everybody's thinking that it's Texas. And I think the reason you're thinking that, you are correct, it's Texas, is that same extended home state rule that we just saw in the last question. So Kelsey is saying Texas is a home state. She could try and get temporary emergency jurisdiction in Oklahoma. That's true. She's not in Oklahoma, so it may be less convenient for her, but that's true. Oklahoma could get involved on a temporary basis. But Texas is the extended home state because it's only been since November. So last November, 1 month, that the child has been in the new state. It's within that 6-month window after removal. So definitely Texas is the extended home state. And what typically might happen is Maria might try and get representation in Texas, try and get the judge in the home state to enter an order, and then she would try to get that order enforced in Oklahoma. I don't know what folks on the line have seen. Typically, what we see is that it's not so easy to get law enforcement in a new state to enforce a court order for custody or even visitation in a different state. They look at the order, they might not recognize it. Typically, they're going to require that whoever wants the order to be enforced go to court in the enforcing state, get the order registered, and get what's called a pickup order. And at that point, law enforcement in the new state, or here in Oklahoma, could help get the child back to Maria. So it can be complicated. If you're trying to assist the survivor with this type of case, feel free to call us. We do keep a database full of folks all over the country. So if you need to talk to your counterpart in another state, we may be able to give you a referral for these kinds of cases as well. And I see a number of you on the line we have reached out to in the past for assistance with either providing a parental kidnapping consultation to a survivor, or representing a survivor, or giving advice to an attorney from a different state. So thank you for doing that. All right, we had Kimberly said very difficult, had to do that in Oklahoma once for South Carolina order. I wish I knew about you all then. Well, good for you for trying, and we are here to help you with those kinds of cases. And we know it's very difficult for survivors when perpetrators have held the children over in another state. We saw that, thank you, Catherine. We saw that, and you have been a great resource in Oregon as well. With the pandemic, we have seen quite a few perpetrators holding kids over in different states, sometimes giving the excuse that the kids can't travel because of COVID. Sometimes the courts are closed, so it has taken longer to get relief for survivors. But we really appreciate what you all do trying to help survivors maintain access to their children. Okay, so let's do one more question. Question number 4. So here, Sarah obtained a 1-year protection order against Sandy in January of 2020 in Ohio, and it included temporary custody of their twin sons. The protection order expired in January of 2021. The couple separated in August of 2021, and Sarah moved with the children to Georgia, where her parents live. Sandy filed for custody in Ohio on November 10th of 2022. I'm going to give you a minute to review the facts and think about those dates, and then please either answer verbally or write into the chat which state has jurisdiction and why that is. The parties, let's say the parties are married, but in some states that might matter because of the need to establish paternity. It doesn't really matter under the UCC-JEA though. Okay, we're seeing some folks saying Georgia. Yep, Georgia is correct, and they've been there for more than 6 months. Yep. So let me suggest a way to analyze these cases, which can be really complicated. Sometimes we hear from attorneys that folks have moved around, 10 different states over the past couple of years, especially because of the pandemic. So we do have a relocation checklist, and we're also going to be developing a sample intake form. But the idea is you want to look at the date when the first parent filed for custody, because under the UCC-JEA, the important date is the date of commencement of the proceedings, which means when did the parent first file for custody? So in our fact pattern, Sandy filed for custody on November 10th, 2022. And then you want to look back in the previous 6 months to see what was going on with the children, where they were living during that time period. So really the only relevant time period here is the 6 months before November 10th of 2022. So what does that bring us back to? May 10th, between May 10th and November 10th of 2022. Where were the kids living? Well, the kids were already living in Georgia. So Georgia had become a home state for the children. And so Sandy is in the wrong state of Ohio. And basically Sarah needs representation to try and get this custody case dismissed because Ohio does not have jurisdiction. I know we put in a bunch of other facts as sort of red herrings. It could be if a protection order was still in effect, and I know we just heard from one of the attorneys on the line about something in Texas that may be a bit different. But generally speaking, if a protection order is still in effect and there's a custody provision in it, and it was entered by the home state, that is going to give rise to continuing exclusive jurisdiction while the protection order is in effect. But in our fact pattern, the protection order expired in January of 2021. So it's not relevant anymore. There's no pre-existing custody order that's out there. So if you have any questions about this case or any of your own cases, please feel free to contact us. But that's just a little bit of practice with the UCC JEA. I do recommend for those of you who are new to the subject matter that you seriously consider coming to our intensive training that is going to be taking place in March. It is both a presentation of the material and an opportunity to make mock arguments to judges and to really practice with these sorts of legal concepts. So please take a look at the dates, see if they match up with your schedule, and if you'd like to join us. And now we are going to take a look at our final topic, and that is the topic of, is it legal for Lila to leave the state with her children?
Thank you,
Next.
Deborah. Next slide, please. So in addition to the state relocation laws, there are parental kidnapping laws in each state from which the person is fleeing. So in Lila's case, it depends on the parental kidnapping laws of Tennessee. Next slide, please. So it's important to know that there could be criminal repercussions when one parent takes a child from one state to another. Every state has some kind of law about a parent leaving the state with the child. It's very important that family law and protection order attorneys be familiar with these laws before advising survivors to leave the state with their children, because it could subject the survivors to criminal charges. So these criminal laws have different names depending on the state. So in some states, it's called parental kidnapping, in others, custodial interference, child abduction, child concealment. Just depends on the state. Next slide, please. So even if a court has never entered a custody order yet over the child, a survivor could be subjected to criminal charges in some states for leaving the state with the children. In some states, it's illegal to leave with the children if there is no custody order in place, if there is a custody order in place, and the order is violated. In other states, even if a custody order has never been entered, a parent may not leave the state with the child in order to keep that child from the other parent. Some states, the laws are unclear, and in others, the laws criminalize fleeing in both contexts, but have more serious consequences for violating an existing court order. Next slide, please. So what type of intent is required? So this varies by state as well, but usually the parent must intend to do something more than just leave with the child. Some states require an intent to conceal the child from the other parent or an intent to deprive the other parent of visitation. Next slide, please. So as you can see, some states have exemptions while others have defenses after the survivor has been charged with the crime of parental kidnapping. So depending on the state, some of these protections are found in state statutes while others are found in case law. Next slide, please. So some states exempt domestic abuse survivors from prosecution. Usually what is required is that the survivor report to law enforcement or a child abduction unit before leaving the state and then file for custody within a specified time period. This may be hard for survivors, and we strongly urge survivors to speak to attorneys before leaving the state. Next slide, please. So unlike exemptions, defenses require at least the initial involvement of the criminal justice system and are only invoked once the survivor is charged. This means that survivors may be arrested and jailed before being allowed to raise a defense. Next slide, please. So once charged with parental kidnapping, a survivor in some states can invoke a few legal defenses. So these may include that she was fleeing domestic violence, she was fleeing harm to herself, fleeing harm to her child, and finally, that the survivor fled out of necessity. In other words, that there was no reasonable action that could have been taken except to flee. Next slide, please. Advocates and attorneys should be familiar with these laws because the consequences of fleeing can be dire. The survivor could be charged criminally and jeopardize her custody case in the short and long term. In the short term, a survivor could temporarily lose custody of her children to the batterer while she's incarcerated, even if she ends up eventually gaining custody of her children. Additionally, if the civil court judge hearing the custody case perceives that the flight was a way to deprive the perpetrator of his children or as an attempt to forum shop, then the judge might grant full custody to the perpetrator. Parental kidnapping charges can negatively affect custody decisions for many years. For immigrant survivors, the consequences are even more dire, with the risk of deportation for a criminal offense. Next slide, please. So what can you do practically? So you can research your state's criminal laws and figure out what the standards are. You can provide basic information regarding the criminal laws that apply, as well as the legal protections available in civil laws. Assist survivors in finding defense attorneys if they are charged with parental kidnapping. You can develop relationships in advance with public defenders and prosecutors. We also recommend that you connect the survivor to any support throughout the criminal process. For technical assistance in cases where the survivor is charged, we recommend the National Clearinghouse for the Defense of Battered Women. They work with domestic violence survivors who are charged with parental kidnapping. They can speak with survivors directly or provide technical assistance to attorneys. Next slide. I'm going to pass it back now to Deborah to wrap it up and open it up to questions.
Thank you, Maria. And Taylor, why don't we stop the share now so we can all see each other a little bit more, and we're going to open it up for questions. I see we have one in the chat. The question is, can we argue that intent to seek safety for yourself is distinct and different from intent to deprive the other parent of contact? Yeah, that sounds like an important argument and one that would be brought up in those kinds of criminal cases for sure. As Maria said, the National Clearinghouse for the Defense of Battered Women has a lot of expertise on criminal defense issues, and there are attorneys on staff there that could be very helpful. If I know that most of you are not handling the criminal defense issues, but if you're trying to connect your client to technical assistance in those cases. All right, great. Well, we've got a little bit of time left, and I know you all have a second piece to do at 3 p.m. with Nnedv. So I'm just going to open it up for any questions on jurisdictional issues right now. We'll stick around for a few more minutes and see if you have anything, whether it's about what we said today or you just have some general questions you'd like to discuss. And one thing, while we've got all of you on the line, one thing that is of interest to us is to know whether some of the procedures that were put in place during the pandemic are still for interstate issues and court proceedings are still going on. So if you could write into the chat, or if you feel like discussing whether or not your local courts are still permitting hearings by video, that's something that we're interested in tracking. So we've got someone who said yes. And as you can imagine, in these interstate cases, yes, in New York, great. It can be so helpful to survivors to be able to remain safe in the refuge state and be able to participate by video. And that was not as common a few years ago. Yes, in Minnesota, great. Oregon, it's much easier with emotion. Oh, good. Some people are saying they have to specifically be requested. Oh, and although somebody in New York said yes, here's someone in Rockland County who said they're requiring personal appearance. Interesting. John is saying the Minnesota first hearing is one way, the second is another. And it seems pretty variable in some states. That's what we've heard in Pennsylvania as well, that it's really different. It's county by county at this point. Depends on the judge. Okay, great. Thank you for sharing. If there's anyone who's on the in Oklahoma, you can ask, but it's sometimes difficult. Yeah. Okay, we have an unusual advantage today where we have folks from all over the country here. And that's something we really enjoy in our basic Interstate Institute and the advanced trainings as well, because sharing information across state and tribal lines can be really helpful. I'm wondering if there's anyone who answered early on when we asked folks if you had ever made an emergency jurisdiction argument, if someone would be willing to share what the argument was and whether it was successful, just to kind of help some of the other attorneys on the line who may be newer to the issue. So anyone who's willing to share either about an emergency jurisdiction argument they've made or an inconvenient forum argument, please feel free to unmute yourself and share with the group.
Hi, I'm Lorna Zen. I practice in New York City in the 5 boroughs. I had a case where our client lived in Pennsylvania, Philly specifically, with her husband and her in-laws, and she fled from Philadelphia to New York City, primarily because she had no family here either, but there are a lot more Chinese-speaking DV resources here in New York City, and there was shelter available to her, where the shelter staff spoke Chinese as well, and so she had no resources in Philly. She filed for an order of protection here in Philadelphia, here in New York City, on behalf of herself and the children, as well as against her husband, but also against both of her in-laws. It was sort of not just a DV situation from the husband, but also from the in-laws. There was no child abuse of the kids who were relatively young anyways. One was of school age, one was not. So she pulled them out of school. After she filed just for the OP, the father's family appeared on the OP in New York and accepted service and hired an attorney here. And then they filed for custody in Philadelphia. We also filed for divorce. We could not file for divorce here, sorry, but we filed for child support here in New York as well. So we did file an emergency UCCJEA application after filing our own custody petition in New York. From what I'm trying to recall what ended up happening. There was a lot of factors that were considered, but ultimately the court declined jurisdiction on the Pennsylvania retained jurisdiction on the custody case, in part because the husband had a disability. That was like the biggest clincher for them, even though our client was unemployed. It was that factor, plus I guess we were able to get her a legal aid attorney in Philadelphia to represent her on the underlying custody. And so the judge felt like she wasn't, what is the word? She wasn't disadvantaged by the custody case remaining in Pennsylvania. The children were not ordered to return to Pennsylvania, though. They kept being here in New York. Custody orders were issued from Pennsylvania, but all the visitation happened in New York for the most part, except for like the final settlement. I think the kids had some like extended visits over the breaks in Philly. And then the final orders of protection were also issued here in New York as well. So it was sort of like both jurisdictions kind of had. And then Pennsylvania constantly was looking to New York because the kids were on the OP to see what would happen with the OP case before they made orders regarding visitation, because there was also an issue with the fact that the children didn't have attorneys on the custody case in Philadelphia, and children have attorneys essentially as a matter of right in New York State once they're above like a verbal age.
Great. Thank you so much for sharing that. That really highlights a number of the issues we were talking about, and actually is the flip states from our scenario. So I appreciate what your advocacy was, and thankfully your client and the children were able to remain safe. Thank you for sharing that. And I see that we have a description from Brooke of a case. She represented a client who had fled to Indiana afterwards. The abuser filed in Oklahoma. The court required the survivor to return, but Brooke was able to represent her, and she retained custody as long as she returned to Oklahoma. So a situation where she retained custody but had to go back to the original state. Thank you for sharing that. The description of the case involving New York and Pennsylvania raises for me another issue. New York is one of the only places I'm aware of where counsel is appointed in family law cases for folks who cannot afford representation. I'm wondering if you all would mind writing into the chat if your state or your county gives free legal representation, not in legal aid where folks have to apply, but as a matter of right, where anyone in a custody case is entitled to appointed counsel. I'm not aware of places other than New York where that's been the law. We're seeing a lot of no's, wish it was. Sometimes judges will appoint someone in a protection order. Okay. A lot of no's, but some in South Carolina, if DSS is involved or initiates a case. Okay. Sometimes in Minnesota for paternity. Sometimes for juvenile dependency. Okay, thank you. Thank you for your responses. That's in keeping with what I've imagined. Oh, and sometimes in Washington State in certain protection order cases or in family law cases if there's a disability. Okay, great. Well, we know it's just critical the work that you all are doing representing survivors in both protection order cases and long-term family law cases. And again, we are here to support you with cases involving interstate issues. Please feel free to reach out to us by phone or by email, and we will get back to you just as soon as possible. And when Taylor reaches out to you, please return her phone calls or email messages. And at this point, I'm going to turn it back over to the folks at OVW and TA to TA Project. And thank you again for hosting this webinar. We really appreciate your help in that.
All right, everyone, just like the last couple of days, we are going to go ahead and take a brief break. The next group will be joining us right at 3 p.m. Eastern time. So go ahead and take the next several minutes and we'll reconvene just a couple minutes after the top of the hour and turn it over to Nnedv, which is the National Network to End Domestic Violence. Thanks, everyone. And thank you so much, everybody at LRC. It was wonderful to hear your presentation. It was wonderful to hear your presentation. All right, everyone, it is 3 p.m. So go ahead and come back from break. I hope you got a good stretch. It looks like Ade says she's having camera issues and she's working with her IT team to troubleshoot a little bit. So you won't see her on camera, but hopefully you see her slides up here. I certainly do. And with that, I will go ahead and turn it over to Ade with the National Network to End Domestic Violence. Ade, can you hear me?
Yes, I'm so sorry about that. Good afternoon,
No
everyone.
problem.
Good afternoon, everyone. My name is Audace Garnett. I'm with the Safety Net Project at the National Network to End Domestic Violence, also known as Nnedv. I would like to welcome you all to today's webinar titled Technology Misuse and Safety Planning. I hope that you all are well. While we're settling back in, just so I can know who's in the space, can you please drop your name and your organization if you feel comfortable doing so, just so I can see who's in the room. I just want you all to note that, again, this training will be for 2 hours. We will pause at 4 p.m. Eastern for a 10-minute break, but please take care of yourself throughout the training. Do whatever you need to do to remain present, stretch, stay hydrated, use the restroom, move about. I won't be offended. I can't see you anyway. So don't be afraid to ask questions as well. Although, you cannot see me, I am going to be monitoring the chat box. So please feel free to drop any type of question that you have. I know oftentimes when people hear the word technology, folks may get a little anxious around what are we going to be talking about. I am an advocate. I do not have a background in IT. I do not have a background in coding or anything like that. My background is with working directly with survivors, and everything that we're going to be discussing today, I learned through having conversations such as this. And believe me, you know a lot more than you think you know. So let's just hop right in. So I just wanted to thank OVW for making this presentation possible. The funder of this presentation is the Office for Violence Against Women, Department of Justice. So I just wanted to put that slide up there. I wanted to share a little bit about the Safety Net Project. At the Safety Net Project, we address the intersection between technology and abuse. We provide technical assistance and training to advocates, law enforcement attorneys, anyone who works directly with survivors of sexual assault, domestic violence, trafficking. So if you have any questions after this webinar, feel free to contact us. We provide technical assistance throughout the week. We also advocate with policymakers and technology companies on how they can enhance their technology to make it safer for survivors to access. We also look at how technology can be misused, which is what we're going to be talking about today, how survivors can safely relocate. We look at how survivors can also strategically use technology through an empowering lens. And lastly, but so important, we also focus on how to keep survivor data safe and confidential as we are, working with their data. Here are our learning objectives. Today, we're going to understand our tech safety principles, which guide our work. We're going to recognize common technology misuses. We're going to build skills for safety and privacy planning and documenting abuse. And then we're going to analyze agency use of tech to protect confidentiality. Let me just say this, all of the content that we're going to be discussing today, we can actually have an entire conference on this. In fact, we do every year, where we spend about 4 days having a conversation around this. It's going to be a lot of content that I'm going to be discussing. So please feel free to ask questions and follow up with me afterward if you have any concerns about anything that I mentioned, because it is going to be a lot of information to pack into the 2 hours. Okay, so why should we learn about tech? We should learn about technology because survivors use technology daily, right? And also technology is a tactic of abuse that abusers are using, right? Whenever technology, a new form of technology comes out, an abuser is figuring out how they can misuse that technology. There are also privacy and safety risks, even for people who avoid or can't access technology. For example, even if the survivor does not have a digital footprint, even if that survivor does not use social media, their information can very well still live on the internet. It can still be out there, and that can cause harm as well. So it's important that we learn about these ways that abusers can access that information so that we can help survivors safety plan. And also how we use tech within agencies and partnerships impacts confidentiality, which we're going to address towards the end. So before we begin, I want us to do a quick activity just to get us started. What technology items can you not live without? Just drop that in the chat. What technology items can you not live without? Because I want to say about 10 years ago, there were some forms of technology that we currently have access to today that did not exist then. So what can you not live without? I see a lot of folks dropping cell phones, laptop, okay, their tablet, okay, yes. Awesome, yes, great. No one said GPS? For me, it's GPS. I don't know what I would do without GPS. Someone said DoorDash. Okay, Wi-Fi. How can we live without Wi-Fi, right? Smartphone, tablet, social media. Yes, absolutely. Thank you all for participating and sharing that. It's so important that we put this out there because, as I said before, a lot of this technology that we're engaging with and that we use did not exist maybe 10, 15 years ago, right? And now that technology is being intertwined into our lives and our work, right? So our personal lives and our work. So it's so important that we think about this, right? I don't even think that there's a day that I can go without technology, but once upon a time we did. So thank you all for participating with that. So let's get on the road to safety. I'm going to start out with discussing our fundamentals. This is so important to our work. This is just laying the foundation. So new tools, old behaviors, same goals. So even if the tools, the tablet, the laptop, the whatever device that you're purchasing, the platforms, whether it's social media, messaging apps, the devices, even if all of those tools feel overwhelming, it's important to recognize that the underlying behaviors are the same. So here we have on our screen the various tactics of abuse, right? This is all about stalking, surveillance, isolation, emotional abuse, and ultimately it's all about power and control. If you've been working with survivors, you're familiar with all of these behaviors. The tech is just a new tool that the abuser is using to get at those same goals, the power and control. So you don't need to be a techie person to talk about technology. And these behaviors are all the same, right? So I like to always take a moment to recognize this. As I mentioned, I don't have a background in IT. These are just new tools that need to be discussed as we are safety planning, as we're doing intakes, as we're connecting with survivors, because more than likely, abusers are misusing that technology. So I just wanted to put that out there, and we'll get into a lot more of this in a few. But back to our foundational principles. These are our foundational principles at Safety Net. If you've ever been to any Safety Net presentation before or to our tech summit, you will have heard us talk about our foundational principles. These are incredibly important to us, so we always take a moment to recognize them, and they also will be woven throughout everything that I talk about today. So number one is tech isn't the issue. It's important that we focus on the abuse, right? The abusive behaviors. Tech abuse is just one aspect of abuse that survivors experience, and it may not be the main form of abuse that is occurring in the survivor's life. So with or without the technology, the elements of power and control remain as the dynamic in that abusive relationship. Survivors need and use tech to enhance their safety, to reach out to friends for support, to contact a hotline, or to find shelter, right? Tech is also a tool that survivors can use to search for jobs. They use it to attend school online, to join a support group, to decrease their isolation, to contact their child's teacher, right? And so much more. So it's important that we see this as an empowering tool that can connect them to the resources and support that they need in order to get the help to rebuild their lives. So technology is not the problem. And I'm going to get into, you're going to hear me repeat this over and over. Because it's so important to talk about this, because oftentimes I've heard advocates, law enforcement, and many others who are working with survivors telling them that the technology is the problem, they should just get rid of the tech. So number two, survivors have a right to technology, right? For some survivors, it may be their lifeline. As I said, I've heard, in spaces where they're like, you need to change your number, or you need to get rid of your phone. That is not right, right? Technology is a right. Without access to technology, survivors have no access to connection, right? And connection is so important, right? Look at how we're connecting here today. It's so important for technology to be in the life of the survivor. And then it's important, if they do want to remain on a certain platform, to strategically help them remain on that platform by safety planning, by maybe changing the settings on that platform, or maybe blocking that person. And we'll talk a little bit more about that safety planning, but getting rid of the technology or the device or changing the number will not stop the abuse. In fact, I've heard of situations where survivors have been told to get rid of that technology. For example, a former colleague of mine was working with a survivor where they told the survivor to change the number, and the survivor said, no, I'm not changing my number because I want to see what the abuser is doing. I know that on such and such date, they often send me numbers. They often harass me, rather. So thank goodness that the survivor did not change that number, because the abuser sent the survivor a photo of a weapon, right? And the survivor knew that it was the abuser because of the tattoo, distinguishing mark that was on their hand, right? And the survivor was then able to leave the home where the abuser was coming to threaten her. So without her being able to see that the abuser was sending this threatening message, she would not have been able to safety plan and get out of that home safely. So it's really important that we think through how we safety plan, because had she blocked that person or changed that number, she would have gotten harmed. So we have to think things through when it comes to that. So it may actually make the situation escalate. So we have to be really strategic when we're safety planning with survivors around using technology. So foundational principle number 3, I feel like I'm preaching to the choir with this slide, because I know that you all are experts who are trauma informed, and you allow survivors to lead their safety plans. But I have to say, this safety planning should always, always, always include tech and be individual, survivor driven, and empowering. It's not a checklist. It's about risk management. For example, I did a technical assistance last week where a few advocates reached out saying that the survivor wanted them to reach out to provide resources. However, when they called, a male answered the phone. I asked them, had you asked the survivor, should you call during a certain period of time? And they said yes, right? So they checked off all the boxes. The survivor said call between 3 and 5 p.m. on Friday, and they did that. However, the abuser still answered, right? So they did the right thing. However, in that case, the abuser still answers. So it's important that we ask survivors, can I call you at this number? Is this a safe email for me to reach you? On what dates can I not contact you? Should I leave a voicemail? Is there a safer way for me to contact you, right? And we all know that what's safe today can be unsafe tomorrow. So it's really important that we always have some type of contact, some type of conversation around the technology that the survivor is using to connect with you, so that they can safety plan around that. Any questions around any of these principles that I mentioned before I jump ahead? Any questions? Any thoughts? No? Okay. All right. So again, here are the various tactics and behaviors that we see with tech misuse in many of the cases that you all see and that we've been seeing at Safety Net. What's important to know and understand is that these behaviors are similar with or without the technology, as I mentioned. For example, the intentions behind stalking through technology are usually the same as the intentions for non-digital stalking. What the tech does is it amplifies the behavior. It makes it faster and louder, and sometimes it may not be as easy to detect right away what is happening. So I wanted to highlight the deepening of the trauma. If a sexual assault gets posted on a social media platform, for example, right, the survivor is not dealing with their trauma in a private way. It is now public, right? And the survivor is not able to control who sees it. They're not able to control if it goes viral, right? If somebody's recording it with another device and then posting it on another platform. how many times it gets forwarded. So that trauma is deepened. I remember a case that I worked on when I was an advocate in Queens, and I worked with the survivor, and the abuser had put up about 60 profiles on one of these major platforms. Every time the survivor got the page taken down, he would put up a new page and share nude photos of the survivor. Every time the survivor took down the photos, took down the page, had them removed, he would then put them back up, right? And this was extremely traumatizing for this survivor, because at that time, the survivor was applying for a teaching position. And every day, the survivor had feared that her potential employer, which was the Department of Education, would find these photos of her, find these photos through, searching or through a background check. And her anxiety was so heightened, she could not sleep. It impacted how she took care of her children and how she navigated her day, her daily activities, her appointments, right? It was so harmful to this survivor. So it's really, really important that we think about the trauma that is connected to technology misuse. We can't minimize it because it's not happening in person, because it's as harmful as it is for a person that's having direct or in-person domestic violence. I also wanted to highlight gaslighting. Abusers can make a survivor to feel like they're losing it, or what they're seeing is not real, because the abuse can feel insidious. It can feel stealthy, constant. It can feel sneaky. For example, a survivor may see a post with a threat, right, that was posted of them on a platform, and before they are able to screenshot it or preserve it in whatever way, the abuser may remove it, right? So now if the survivor goes to an advocate or to the police, or tries to report it, they may not be believed, because where's the evidence that this happened, right? So the technology can make the survivor feel like their reality is off. So it's really important that we just listen to survivors, because this technology, as we are going to, talk more about, can, really be stealthy, sneaky. It can, appear and disappear before that evidence is captured. Any questions about that before we dive into navigating the world of devices and location? Can I get a thumbs up if y'all are still there? Are you still with me? Or yes, or amen, or something? Are y'all still out there? Good, good, good. Awesome, awesome, great. I'm glad that you all are still there. So now we're going to dive into navigating the world of devices and location. I know that this is a topic that you're probably seeing on the news a lot, with people being monitored. But I want to dive in first to start talking about device spying and monitoring, right? So as I mentioned, this is one of the ways, the monitoring, right? These are, there are several ways that monitoring can happen. So there's a spectrum. There's simple to complex. So on the simple side, what can happen is an abuser could know the passcode to the survivor's device. They could pick up that device and see that the survivor has been texting their attorney or their advocate. And the abuser can then see that the survivor has an appointment or whatever conversation is being had. So that's the simple side, right? But on the more complex side, what could be happening with monitoring is the abuser could download something on the survivor's device that could monitor what the survivor is doing. And I'll share a little bit more about that as we talk about spyware. But when it comes to device spying and monitoring, again, physically accessing that phone, accessing usage records. Another way that an abuser could monitor a survivor is through looking at a phone bill and seeing that the survivor contacted an advocate, looking at a phone bill and seeing that the survivor contacted the police precinct, right? Mobile phone statements, as I mentioned, credit card statements, right? If they share the same mailing address, right? And the credit card statement goes to the home, and the abuser opens that credit card statement and sees that the survivor maybe purchased a new cell phone or purchased something to aid in their safety plan, right? These are all ways that the abuser can monitor what the survivor is doing. Files, emails, if the abuser has access to files that are sitting on a desk, right? Emails, files on the computer, voicemails, right? If they're able to remotely monitor those things by just picking up the device as well, right? Family plans, if they're a part of a family plan, the abuser can, you know, monitor what the survivor is doing, see who they're connecting with as well. Using apps, installing apps, these are the various ways. So we're going to talk a little bit more about that, but I just wanted to put that down. So when it comes to mobile device stalkerware, so spyware or stalkerware, this is something that we don't oftentimes see, but it is something that abusers can use. Now, stalkerware and spyware is oftentimes advertised as a tool that people can use if they have a parent that has dementia, or if they have a child that has autism that wanders, right? You may want to put this mobile stalkerware on the device so that you can track their location, right? So technology was not created for malicious things, right? It's the misuse that we're hinting at today, right? That we're talking about rather. So it's the misuse. So what stalkerware is that it's a it is a mobile. It's mobile as well as you could download it on a computer, but it's software that a person needs to have access to that device in order to download that software. Once they download that software onto that device, they are then able to monitor everything that is happening on that survivor's device from their cell phone, right? Or from their computer. So they're able to track their location. They're able to see who they're texting. They're able to see what emails are being sent, what photos are being taken, so on and so forth, right? Again, this is not something that we commonly see, but stalkerware is something that can be purchased online for, you know, a reasonable price, $49.99, right? Depending on how robust you want the stalkerware to be. So this is something that is not too common, but we do see it sometimes. What we have seen during the pandemic is that there was a 51% increase in the use of online spying and stalking apps during the lockdown. So keep that in mind. Abusers were, you know, figuring out other ways to do that. And when it comes to computer stalkerware, it does the same thing, but it just would monitor what's happening on that computer. Are there any questions around that? Awesome. Okay. Yep. Great. So how do I know that it is there? So usually it's difficult to identify that this spyware is on this device, but some signs can be the battery drains quickly. So the survivor's battery would drain quickly. It's warm most of the time. It takes longer for it to shut down. The screen may light up when it's not in use. Incoming calls on statements were not received, and spikes in data usage, right? But the main thing that we'd have to ask a survivor if they do think that stalkerware is on their device is, did the abuser have access to that phone? Did the abuser have access to that device, right? If they did not have access to that device, then you want to rule this out. Maybe it was a Post-it note that was left on the computer and the abuser saw it, right? Maybe it was a child in common that went on a visit and shared, you know, that mom was going to the advocate's office, right? So you want to find out where that information lives, but most importantly, did the abuser have access to that device? If they did not, most likely it's not stalkerware, right? So how do I get rid of it? Oftentimes it is difficult to remove stalkerware. It operates like a ghost file. So what it does is it can attach itself to your photo gallery or to another app. So you may think that because you reset the phone and because once you do a hard reset, it removes a lot of content off of a phone, off of your device. Resetting it could work, but a lot of times it does not. What we suggest is that a survivor uses a phone that they do not feel is being compromised. Maybe a phone at the library, or maybe a phone at work, or maybe a phone somewhere in the community, a neighbor or someone that they trust. Do not use that device if it's being monitored. So Spyware is something that we talk about. I will send you all a list of resources so that you can look into this a little bit more and learn a little bit more about that. So spying with everyday tech, again, it's not always spyware, right? If the abuser has access to the survivor's cloud accounts, and how do you gain access to a cloud account? You just need the password and the email, right? And you can log in. Family plans, right? Family plans give you access to so much data, right? It can share location and so many other things. So these are other ways. You may want to ask the survivor, do you share a family plan, right? Does the abuser have access to your cloud account, right? Did you change those passwords? Social media. If this is a person that the survivor has, known for some time and the abuser knows their security questions such as the mother's maiden name and the school mascot and their favorite color, the abuser can easily log into these accounts, right? Hack these accounts, log into their bank accounts. Maybe they share accounts, right? So that data that's being shared in those accounts, the abuser could easily see, if the survivor has relocated. For example, in a banking app, if a survivor relocated, let's say to another state, that transaction will show that that survivor is in that current state. So you want to ask questions like that, right? Do they have access to these apps? Do they have access to any of these accounts? Because that's where that data and that information lives, right? Before we jump ahead and talk about Internet of Things, any questions about those few slides that I just mentioned? Okay, all right. And you all, I didn't realize it, but you all can also unmute yourself. So please stop me if there's anything that I said that you would like me to repeat, or if there are any questions, please feel free to do that. So Internet of Things, let's talk about the Internet of Things. Anyone familiar with the Internet of Things? Does anyone have any devices connected to the internet? Any smart home devices? Anybody have an Alexa? Anybody have a Google Home? Anybody have smart locks? Anybody have a smart thermometer, a smart refrigerator? Come on, let me know, let me see, don't be ashamed. Some people said no. Yes, Alexa, a lot of smart items. Yep, doorbell, right? If you have a cell phone, I want to say that that's an internet connected thing, right? Because it does a lot of things, right? We can ask our cell phone questions, it talks back, it does so many different things, right? Someone said they have a smart microwave. Oh my goodness. There are smart crock pots. You would be blown away about all of the things that are connected to the internet. I mean, they have refrigerators that tell you if you're low on milk, right? You're in the supermarket and you can actually log into your app and look into your refrigerator and say, I need mustard and mayo, right? Some people need that, right? Some people don't. No judgment here. So Internet of Things is something that we need to think about and always ask survivors about, right? Some survivors may have internet connected doorbells, right? Anybody work with a survivor that has an internet connected doorbell? Anybody have a case where they've seen situations like that? So it's really important that we think these things through as we're safety planning and having conversations with the survivor, because if that abuser has access to that internet connected doorbell, they can monitor if the survivor's comings and goings, who's coming to the house, so on and so forth. So if the abuser's saying, I saw that you had on a red shirt today, how do they know that, right? Maybe they have access to the doorbell, or maybe they were watching them from across the street. Maybe it's not something that has to do with technology. So it's important that you think these things through. Ask the survivor, what type of devices do you have that are connected to the internet? Does the abuser have access to them, so that you can safety plan around that? I want to play a quick video that I think is so funny. And for those that are not familiar with what internet connected things are, I just wanted to share this. So I'm going to press play right now.
Play jazz.
Playing jazz.
Smoothie.
Making smoothie.
Calendar.
No meetings today. Remember, tandläkare at 9:30.
Fire off.
Fire off.
Open door.
Door open.
Sånn, så skal vi sette en til.
Ja. Open door.
Wrong voice command.
Open door.
Wrong voice command.
Open door.
Repeat that.
Open door.
I didn't understand that.
Hey, open door!
Play on the floor.
Get over the floor! Open the door!
Wrong
Open
voice
the door!
command. Error.
Hey, there, with a rock? Open door. Open door. Open door. Open door. Higher.
Higher volume.
Higher.
Hilarious. I think that video is so funny because it just shows how far we have come. Everything can be internet connected. I've been forced into connecting a lot of things at home into the internet, but I'm an old school person. I really like to just use those keys because technology can fail us all the time. Look at me, like you can't even see me on camera because some setting in my laptop is not allowing me to turn it on, right? So internet is connected into so many areas of our lives. It's intertwined into every area of our lives. It impacts how we travel, how we go to school, how we work, right? When the pandemic hit, everybody hopped on to their laptops and started working from home, right? So without technology, we wouldn't be able to be connected. However, it's the misuse. Technology is not bad, it's the misuse, right? So think about these things as we're having this conversation. Technology is intertwined into every single area of our life. So as you're having conversations with survivors and you're talking about, okay, so how do you travel? If they're saying that they use a GPS or they have a vehicle, maybe something is installed in their vehicle, right? A lot of vehicles come equipped now with GPS monitoring. Does the abuser have access to that, right? If they take public transportation, maybe they have a Metro card, right? Do they purchase that Metro card online? Or now I know that they have, in New York, they have something called Omni, where you can, purchase your rides online, right? And it shows a record of places that you've traveled. Ride sharing apps, right? They send you receipts to your email. Does the abuser have access to that email that shows that you traveled from point A to point B, right? Or from the court to the police precinct, right? Where does that data and that information live? Because it's so intertwined into our lives and into survivors' lives. And abusers, if they have access to that information, can use it and cause further harm. So it's important that we think about that. So here's just a list of internet connected things. You can unlock doors, your thermostat. We actually had a survivor speak at our tech summit a couple of years ago that spoke about her, the abuser who was living in Canada, and the survivor was living in the South of the United States. And the abuser was able to control the temperature in the house because they had access to the app, control the temperature, the music. So they would, make the music loud. They would make the house extremely cold, right? Would monitor the survivor on cameras, so on and so forth. So if a survivor is coming to you and saying X, Y, and Z is happening, listen to what they're saying, because there's so many ways that abusers can gain access to their lives if they know passwords, account information, so on and so forth, okay? Oh, somebody said fitness watches. Yes, absolutely. Yes, yes, yes. All of these things are internet connected, right? And again, these things were created for good. It's the misuse and the harm that is, that the abusers are using. Let's talk about impersonation. Impersonation is something that is really common. You saw the guy with the mask in front of their face. And that is what we see a lot happening, right? One thing that I want to bring up is spoofing. Is that something that you all have seen, spoofing? Have you seen spoofing? A lot of people are saying yes. Okay, yes. So for those that don't know what spoofing is, spoofing gives the caller the ability to change their number shown on ID, change their voice, and you can also record calls and do so many other things, right? I think we're oftentimes spoofed. How many of you receive phone calls saying that your car insurance is due or you didn't renew something, right? And you're thinking that it's actually someone that you know because the area code, you're familiar with the area code, but it's someone calling you saying your car insurance is due. Please press 1, right? We're spoofed all the time, right? But these apps, they live on, various app stores. Some of them are, free. Some of them are sold, for a certain price. And, a lot of them are disguised as, a prank call. You can use it for prank calls, right? Abusers can use this. We've seen where abusers have spoofed survivors to harass them. I've seen where abusers have used, spoofing to call a survivor and say that the court date has been changed, right? We've seen so many ways. Actually, I was doing a presentation in Westchester, New York for some judges, and the judge said that the abuser was calling the chambers back to back to back, and they knew it was the abuser. They didn't answer, but then the abuser changed their phone number to the defense attorney's phone number and got through. The judge answered. The judge was like, oh my goodness, I'm a believer. I could not believe that happened. So abusers can use this as a way to cause so much harm, right? However, we can use spoofing as a way to set boundaries for ourselves, right? If you're meeting with a survivor, maybe to accompany them to court, or maybe you don't have an agency cell phone, you can use something like Google Voice, right, to block your number because you don't want the survivor to have your personal cell phone number, right? Spoofing is not a crime, only when you use it to defraud or cause harm. But abusers use this all the time. And in order for the courts or anyone to, bring this type of evidence into a courtroom, they would need subpoenas, right? So what the courts or law enforcement could do is subpoena the records of the app store, right? To see that the abuser downloaded this, right? Or credit card statement to see that they made a purchase of this spoofing app. So there are ways to figure this out, to find this out. It can definitely show that, or look at phone bills, right? It can show that a phone call came out, an outbound phone call came out of the abuser's phone at such and such time when the incoming call came to the survivor's phone. So there are ways that you can, try to put these puzzles together. But a lot of times the survivor may not, be aware of these things. So I will share resources and information around this as well. Location tracking. Any questions about the spoofing? Any comments that anyone has around that? Okay, cool. All right, so let's talk about location tracking, folks. So locator plans and apps. So as I mentioned earlier, family plans. Anybody have a family plan in the room? Anybody have a family plan? No? Yes? Okay, a few folks. Awesome. So with those family plans, you can see so many different things, right? You can monitor, where that person is. You can set it up where you can monitor text, photos, so many different things. Locator apps as well, right? These are all things that you want to ask the survivor. Are you a part of a family plan? You want to ask the survivor, are there any apps on your device that you think don't belong there, that are new, that may seem like it's off? You want to talk about those things. Open up the survivor's device, take a look at what's on the device, and then Google it, right? You Google it and see what it's about, so that you can then try to figure out if that app is what's collecting that data and that information. It's kind of like putting a puzzle together. So mobile phones and location settings. So I had no idea about this until a couple of years ago, right? So if you, on the left, Apple, on the right, Android, in your settings, right, you can turn your location off and on, right? A lot of times these apps are collecting so much data, so much information from us, about us, and we have no idea, right? When we download that game, Candy Crush or whatever you play, right? Do we read the terms and conditions? Anybody want to be honest? Does anybody read their terms and conditions? When they say, give me access to that camera or that microphone, do you say no, or maybe so? Don't be ashamed. It's okay. You just want to get to that Candy Crush, right? You want to play your game and decompress from having a long, hard day, right? But a lot of times these apps are collecting data from us, right? So it's important that we talk to survivors about this as well, right? Because a lot of this a lot of these terms and conditions, these agreements that we're clicking yes on, maybe collecting information that we don't want to share. And a lot of these companies are selling our information, and that information can then end up online, right? And if that information ends up online, the abuser can do a simple Google search and then find our information, right? They sell our data to big companies as well, right? They want to know how many times you went to Starbucks. They want to know how many times you went to Bath and Body Works, right? They want to know what trends, what type of trends we're into, right? So it's important that we think that through. Not only apps on our cell phones, but apps on our smart TVs, right? That's a lot of data being shared as well. I know I'm getting ahead of myself, but data lives everywhere. Amazon has your data, Netflix has your data, right? When you swipe that Starbucks card, that has your data, right? They know that you're getting that grande caramel frappuccino, right? With extra whipped cream and crunch. Now I'm giving away my information, my data, but that information lives somewhere, right? So not only is this a misuse issue, it's also a consumer privacy issue, where our data is just being given out freely, right? And possibly being sold and ending up online, right? And that can then impact survivors in a negative way. So it's important that we think about all of these things. Have the survivor look at their settings to see what information they're sharing, right? What information is being given. For example, Google Maps. Anybody use Google Maps? Anybody? Okay. Yes, all the time, every day. Okay, yes, awesome, all the time. So you all should be familiar with Google Maps. Do we all know that Google Maps has a timeline? If you were to go into your settings, your history of location, it'll show you the places that you visited. It'll also show you photos that you've taken, how you got there by plane, subway, if you walked, right? It will show you all of this information, and that's data. If the abuser has access to that Google account, they can easily log in and see that, the survivor went to Hamilton Place and they took the bus and then they got off and took the train, right? So it's important that we go into our settings and turn that off, right? Go into our settings and turn that off, because the survivor does not want that information to be captured and stored in their device if the abuser has access to that information, right? A quick tip, Google. If you go to Google My Activity, it's a one-stop shop to manage Google privacy. So what you would do is go to google.com, you would type in activity, and it'll tell you where on what devices you're connected to and what information you're sharing, calendars, apps, music, all of that, right? So you can then go into those settings and turn those things off, right? So it's important that we know that every single app that you use has settings. It has privacy settings, it has security settings, right? So it's important that we keep that in mind so that we can, update those things, for safety planning purposes. Many apps collect location, as I mentioned. Some apps do need your location, right? For example, if you're using a ride-sharing app or GPS, that app needs your location. Does a bank need your location? Would a banking app need your location? What do y'all think? Would a banking app need your location? Someone said no, nope, never. Well, maybe, right? Maybe they do, to find an ATM, right? To find a branch. Maybe you may want, to have that location on, but you can Google that, right? That's not something that you need to, keep your location on. Does a banking app need access to your camera? What do y'all think? Does a banking app need access to your camera? Some people say no, some people say yes. Yes, right? You can deposit checks. So yes, you may need that. If you deposit checks, yes. Does a banking app need access to your microphone? What do y'all think? I say no. Yes, no. For the person that said yes, why do you think they need access to, or the person that says depends? Yes, if it has voice capabilities, absolutely, absolutely. Possibly, right? But if it does not need access to it, and you don't want that app to have access to your camera and your microphone, turn that off. Go into your app, have the survivor go into their app and turn that off, right? Absolutely. Because when absolutely, they're video tellers, you may need it for that, right? So if a survivor has a app, maybe for, banking with a teller, or maybe for, medical visits, that app may need access to, their microphone and their camera. So it's important that we think this through as we are downloading these apps on our device, and so that we can talk to survivors around how they can safety plan. Now, location trackers. I saw someone mention location trackers earlier. Location trackers can be small and easily hidden. I actually use location trackers to find my keys, my bag, and a couple of other things, right? These are devices that are really tiny. Some of them can be really tiny, some of them can be large, right? They're really affordable. Some of them are less than, $30. You can purchase them in any retail store. They can track the person or object, be active or passive. Some of them you can log into your account or your app and see, where that person is currently or where they were in the past. Again, these were not created to be malicious. It's the misuse, the harm that abusers can do with these things, right? So just keep these in mind as well. Some people have location trackers for their pets. I know that there was a case in New York, Avante Aquindo, I think that's his last name. He was a child that had autism that wandered outside of the school. And under the Avante law that I'm not sure if it passed yet, but what they wanted to do was to provide parents who had children in autism that were in public schools with these type of devices so that they could attach them to their belts. Because what Avante did was he wandered, he left the school, no alarms were on the door, and Avante ended up being harmed. So trackers can be used for good, to make sure that people are safe, right? To find keys. It's the harm that's being that's a cause for concerns. Even luggage, right? You can put it in your luggage. How many people have lost luggage, right? If you had an air tag or some type of tracker in there, you'd be able to locate that luggage. So again, it's not the actual device, it's the misuse that we are concerned about. As I mentioned, car monitoring services, teen driver monitoring, OnStar, a lot of these apps, a lot of these vehicles come equipped with a lot of these tracking capabilities. I did a presentation at a primarily law enforcement conference earlier in spring, and they spoke about all of this access that they've been seeing in their line of work, where abusers are able to control the vehicle, speed up the vehicle, and they're able to monitor how fast the survivor is going, where the survivor went, all through these capabilities that are equipped in the vehicle. They already come equipped in the vehicle. So you want to talk to the survivor. If the survivor is saying the abuser is showing up to my job, how did they know that I found this new job, right? You want to find out if they have some type of tracking device or some type of monitoring that came equipped in that vehicle, because that very well may be the way that they're tracking that survivor. OnStar, a lot of insurance companies give you a discount, for a teen driver discount, if you allow them to monitor your vehicle. You get a discount, and so on and so forth. So many ways that they're gathering data. So again, it's also a consumer privacy issue as well as a misuse issue, right? So it's important that we think these things through and think about where all of this data lives. And I haven't gotten there yet, but all of this data that lives out here can very well be a way for law enforcement, if that's the route that the survivor feels, comfortable with moving forward with the case, they can use that data and that information, to proceed with a case possibly. So, because it is 3:50, I'm going to pause and let us take a 10-minute break. And then we're going to jump into data and how I was alluding to some of this earlier, but we're going to pause, take a 10-minute break, and then we'll come right back. So enjoy your 10-minute break and see you in a few. Okay, I think we are at the top of the hour. So I'm just going to push forward so that we can cover the rest of this content. I hope that everyone is back. And for those who aren't, they will just be able to join us once they get back. Okay, so let's talk about data. Data here, data there, data everywhere. So again, put your questions in the chat if you have any questions, because we're about to start talking about data, and then we're going to do safety planning, and then we're going to dive right into some confidentiality. So from the moment that we wake up, we are generating data with every email that we send, every piece of content that we create and share to our social media profile. That is data. Whenever you swipe your transit fare card, whenever you request a ride through a rideshare app, that is data, right? We're constantly generating data throughout our day. And today, data is one of the most important commodities to data brokers, right? And retail companies, because it gives them more than just a glimpse into our lives. I spoke a little bit about this earlier, right? It can reveal patterns about our behaviors, our habits, probable health outcomes, our religious affiliation, our health conditions, where we live, our likes, our dislikes, and so much more. So as we delve into this conversation, we will learn two things. That data privacy and safety is a consumer privacy issue for everyone, including the survivors that we serve. And it is also a tech misuse concern, because the same data that is being collected online and offline can be misused by abusers to stalk, harass, threaten, and cause serious harm. All right, so what is data? How is it shared? Where does it live? Can someone just unmute themselves real quick and tell me, what is data? How is it shared? Where does it live? And it's not a pop quiz, because a lot of the answers are on the screen. So what is data? I mentioned what it is. How is it shared, and where does it live? Anyone?
All of our information everywhere about everything.
everywhere, including where? I mentioned some places
online,
earlier. Where?
Physical records, paper records.
Yes. What about the data and the records that we keep of survivors, right? Do we keep a lot of records of survivor information? Board reports, we share reports with our funder, right? All of that is data, and it lives somewhere. So it's important that we keep this in mind, right? So our data, it lives on social media. We all know what people ate, right? So it's not even just about, your personal information. We know what people ate, what they drank this weekend, where they traveled, right? Their high school mascot, their birth date, the first day of school for their children, right? We know everything, because a lot of it lives online, right? So people search and aggregation sites. These sites compile personal information that we may have advertently or inadvertently shared. They make it public for anyone to find, and sometimes they charge a fee for access to that data, right? You can find a person's home address, their email, their phone number, and even their relatives' information, right? This is the new, not yellow pages, the new white pages, right? Except it makes it's a lot more detailed, because it'll show old emails, it'll show old addresses. Sometimes it connects you to former roommates. It'll show family or friends, relatives in common, right? If you share the same address, right? And this data and this information is being compiled and collected. How? Sometimes we go into CVS or Rite Aid or whatever store, right? And we sign up for these discount cards. Do we read the terms and agreements? Let me see in the chat. Do you read those terms and agreements, or are you just trying to get your discount? Anyone? Nope, we're not reading them. Sometimes rebates as well, right? We're sending in these rebates because we want to get a lifetime membership of this, or, we want to make sure that, we register this product. That information is being collected and stored somewhere. Where does it live? Sometimes we attend conferences and, the conference host says to download an app, and you're putting your information in that app, right? Where does that information live? Sometimes we're walking through the mall and there's a sweepstakes. There's a car in the middle of the mall and they're like, sign up to win a new Mazda Miata. Anybody sign up and win? Did anybody win the Mazda Miata in the middle of the mall with the sweepstakes? Don't be embarrassed. Okay, all right. I know it's the end of the day. I'm just trying to keep you all on your toes. That's data. That is data. It's data. It's data. Some of us go on vacation and we sign up for that. I don't know, we want to win a free vacation or whatever it is, right? That is data, and it lives somewhere. It's stored somewhere. So be mindful of what you're sharing. We also need to say this to survivors as they are trying to rebuild their lives. If they have relocated, they should not be giving out that data, because it will end up online. An abuser could easily Google that information and now find out where their new address is, right? That information is gathered and it can be posted online, and it's sold because it's big business. There are thousands and thousands of people search sites, thousands of them. And they're currently not that many, there's not any regulation currently. So please keep that in mind. I will share some resources towards the end that you all can use to look into that. So I talked about social media, so I won't dive into that. But a lot of people feel like social media is just like the huge all of the large platforms. Social media includes blogs, videos, photos, chats. If you have a smartwatch, right, there may be a social media community that you can go to and you can find out, how to use the watch, right? If you have, if you shop at a certain store, that's considered social media. If there's a place where you can chat and connect with community, right? Anything that's community specific is social media. It's not just the big four companies that we oftentimes hear about. So here is what a data broker and a people search site looks like. So data brokers are collecting that data, right? People search sites then have that information on their website. So what an abuser can do is not only Google the survivor's name, they can actually go to one of these thousands and thousands of people search sites, put the survivor's name in there, and locate that survivor. So you want to talk this through. You want to have the survivor Google themselves, right? Google yourself and find out if your information lives online, right? And we also need to have conversations with survivors about when they're connecting with organizations. Maybe that survivor relocated and they now want to volunteer, right? If they're going to volunteer, they should have a conversation with that organization and say, I don't want my photo taken. I don't want my name linked on your website, because if it's linked on that website, guess what? If the abuser Googles that survivor's name, they can now see that the survivor relocated to Connecticut or to Florida or wherever they're relocating to, right? So it's important that we say these things. Even if the survivor wants to join the PTA, if they're going to be a part of the PTA and the PTA is collecting information about, who's present, make sure that the survivor notifies whoever's taking the minutes that they don't want their data or their information connected to the school's website, because that's something that could easily be connected to them, and the abuser can now know where they're living and now where the child possibly goes to school, right? So it's important that we keep that in mind. I will share some resources again once we're done. Google is your best friend. How many of us Google ourselves? Google is your best friend. Don't be afraid to Google whatever you want. Don't be afraid. Google yourself. Have the survivor Google themselves, right? Every couple of weeks, Google yourself. See what information is there. Also, Google actually has a tool. Let me make sure that I put it here. Yes, you can set up Google Alerts. You can go to www.google.com/alerts. And once you go to that page, you can then type in your name, right? And you provide an email address. So I would go in there and I would type in Audace or what other social, if I have a social media handle that I want to put on there to make sure that I get alerts. Whenever my name is mentioned in an article or if it's posted by the PTA, I will get a notification from Google Alerts. So it's important that you do this. Remember though, if the abuser has access to that Google account, you don't want to do this, right? The survivor doesn't want to do this because they can easily, change those settings, right? So you want to do it with an account that has not been compromised, right? Oh, was there a joke? My name is popular, it doesn't show. Right, okay, so you have a common name. You have a very common name, right? So those with a common name, right, may have to narrow it down to zip code, right? Or birth date, right? So the less information that you share with the store rewards card places, the better, right? So if you have a common name, it may be a lot harder for that person to locate you. But that abuser can do their research and put 2 and 2 together, and trust me, they will figure things out, right? So what does the misuse of data look like? So harassment, right? If that abuser gathers that information, they could post things. They could send the survivor mail now, right? They could contact that school. They could notify the PTA that, of whatever. They could spread rumors. They can do all sorts of harmful things. They could threaten the survivor. They can stalk the survivor. They can dox the survivor. Do we know what doxing is? So doxing is basically gathering personal identifying information and posting it online. We saw that happening, with a lot of activists that may, be out there, sharing their story. People may want to retaliate and then share that personal information online, and it can cause a lot of harm, right? Swatting is taking that person's personal information and calling law enforcement and saying that some form of illegal activity is happening at that person's home. And then law enforcement shows up to that person's home with a SWAT team. That can be traumatizing and really harmful. And then the distribution of intimate images, right? That abuser, if they have access to intimate images that were shared, consensually, maybe when they were in a relationship, they can then post those images and cause a lot of harm with the survivor's employer, the child's school, so many places that, the survivor's connected to. Any questions around that? So, as I mentioned, posting negative things, facilitating assaults. We saw that there was a Craigslist case where the abuser facilitated a sexual assault, and it was awful, right? Impersonation. They could take that data information and pretend to be the survivor, right? Limiting access to online tools. They can log into those accounts and set limits on, spending, right? They can change passwords. They can change access to Wi-Fi. They can do so many things once they have access to that information. Harassment, posting covert and overt threats, using third parties to, join in and harass the survivor. This can have a huge economic impact to the survivor. Survivors can lose their housing, their jobs. So we really need to take this seriously because this can cause a lot of harm. Any questions about that? I will actually then move forward if you don't have questions and talk about images and safety. So intimate images. So intimate images are not a new thing. Oftentimes when we talk about intimate images, people are like, oh, those young people, what are they doing? Actually, it's very common. Sharing intimate images are very common for partners, young and old. For young people, there may be concern around if this is legal or not. Some young people, I've heard of some young people that have shared nude photos with their partner so that they don't have to engage in intercourse. So that's a way of them, it's kind of like a digital exchange. It's like the digital currency young people use that in order to, connect or build a relationship. and there's an AARP article actually. It's a little old. I always mention it, but I have to mention it because the elderly are sexting too, right? This is something that's common. So it's important that if a survivor comes to us, there may be a lot of shame that is attached to them when they're coming to talk to you about this. So it's important that we don't make them feel bad about, the fact that, there was an image that was taken of them, because it's not their fault. They did not tell this person to share this photo. Maybe they did give consent for that person to take that photo, but they didn't give consent for this person to share it. So it's really important that we support survivors, because this is something that we see a lot. We see this so much, so much technical assistance, so many technical assistance emails and phone calls come through when it comes to non-consensual intimate image sharing. You may have heard of this term as revenge porn. We don't call it revenge porn because it's not about revenge and it's not porn, right? This is the non-consensual sharing of an image, right? So it's important that we keep that in mind. There are advocates at CCRI, the Cyber Civil Rights Initiative. They work directly with survivors and they help take down some of these images. But here are some other ways that these images can be misused. So voyeurism, child pornography. We've seen a lot where young people may be online and they're groomed online. Send me a nude photo. I'll set up a OnlyFans page of you, right? And then that person, is grooming that young person and says, if you don't send me more photos, I'm going to tell your parents, or I'm going to do X, Y, and Z. I'm going to out you. I'm going to share, share information about you online. So it's really important to keep that in mind, that this is happening to young people on various platforms. So if you work with young people, just build awareness around this. Don't shame them. Don't blame them. Just educate them. We have a lot of resources on our website, techsafety.org, around this. I actually did a tech talk with, what a tech talk is a very short conversation. We did a very short conversation with the Cyber Civil Rights Initiative, and they shared tips and information. So I can also share that link to that tech talk so you all can gather information around that. Any questions around that before we move forward? No? Okay. All right. So online abuse has real life effects. Did we get to that point yet? Do you think that we've touched on that? Do I need to spend time on this slide? Yes, no. Are we good on that? Like we've gathered that, right? I don't need to spend a lot of time on this slide. It has real life effects. It can impact survivors. Please keep that in mind. We need not minimize online abuse. We need not minimize technology abuse. It has real life effects. So as we're advocating for survivors, we need to help other folks understand that as well, right? So now let's dive into what can survivors do. Where do we start? So we want to start by listening to the survivor, right? Tell them to trust their instincts because they know their situation better than anyone. Let's say that they said that they're being tracked, right? What leads them to think that their location is being tracked? The more specific the answers that the survivor gives you, the more clues the survivor has to figure out how it's happening, including the possibility that an abuser is accessing an everyday device to track location. Does the abuser know everywhere the survivor is going, or just one or two key places? What content or information do they know, right? You want to ask, like, what did the abuser say? Like, did they mention that you went somewhere? Did they mention that you were with someone, right? Does that information live in the device, or is that something that they could visually see, right? So then you want to start narrowing things down. Could the abuser know simply by asking friends? Maybe the survivor posted, maybe the survivor's social media page is not private. Maybe the survivor has friends in common with the abuser, and the friends in common shared that the survivor was on vacation or that the survivor posted a life update, right? Where does that information live? Family, friends, neighbors, who's sharing that survivor's location? Did the child in common share a photo with the abuser. I remember a case where the child, and it was a teenager, where they were staying in a shelter with their mother, and they took a photo in front of the subway station, right? And uploaded it to social media. That gave out clear information to the abuser about where they were, right? So you want to find out those things. Are the children having conversations with the abuser? Were there photos taken? Like, you want to narrow things down. What kind of access does the abuser have? Do they have access to the survivor's email? Do they have access to the survivor's explanation of benefits? Maybe the survivor is still on their health plan. Do they have access to their device, credit card statements, right? Is there an appointment written in a calendar? Do they have access to the Google Calendar, their Outlook calendar, right? Maybe they have I have two laptops, right? You open one and you can see everything that I'm doing on the other, right? How many of us know that if we Google something on our cell phone, the actual record of what you Googled will show up on your desktop? Do we know that? Give me a yes or a no if you know that. And if you don't, that's okay. I just realized that a couple of years ago, right? So those are things you want to talk to the survivor about. Like, is that laptop in the home with the abuser? Did you search for a shelter on your cell phone while at work? And now the abuser went into your browser history and saw that you searched for shelter, right? So you want to find those things out, because it's really important to get to that. So what does the survivor want, right? Someone said that's only if you use Chrome and if you're signed into. Yes, absolutely. Thank you so much, John. Yes, that is absolutely correct. If you're using Chrome and you're signed into your Google profile, right? So if you're not signed in, it won't sync. But anything that is connected and syncs, absolutely, it will definitely show up. So thank you for reiterating that, John. I appreciate that. So what does the survivor want, right? So as I mentioned, we do not have a checklist because safety planning isn't a checklist, but here's a good place to start. Asking the survivor what they want. And we will discuss this more towards the end. But do they want to remain on the platform and use an option such as blocking the abuser and submitting a request to the company to take down the offense? We need to keep in mind, as we're safety planning, that if a survivor blocks the abuser, you can't reverse that. Once a person is blocked, you can't reverse it, right? And once the abuser is blocked, they will know that they're blocked. It's something that's permanent. It's a permanent action that cannot be reversed. And the abuser will know, right? Which means that the incident can escalate, right? So if that is what they want, talk them through that, right? And help them understand that, because sometimes, as I mentioned with the case that I spoke about earlier, a survivor can, allow the abuser to still be connected to them so that they can check the temperature to see what's happening until they maybe find a safer location, So you want to make sure that you mention that, blocking is something that is permanent. You can't take it back. You can't reverse it, right? So you want to talk about every single option, right? Takedowns can happen. Taking down, a post can happen. You can, report it. Anyone can report a post, right? It doesn't have to just be the survivor. Anyone can report it. If it's against the community's guidelines, standards and guidelines, the platform should take it down within 24 hours, maybe sooner. If there are situations where you all are working with the survivor and, you haven't heard back from a platform, you can reach out to SafetyNet as well. We do have a few relationships with some of the tech companies. So if there are issues where, maybe there's a nude photo or some type of harmful information that goes against the community standards, and you haven't received a response, you can always reach out to us. Does the survivor want criminal charges? Do they want to work with law enforcement? Do they feel comfortable working with law enforcement? Do they want to file a complaint at the precinct? Or are there civil remedies? The law has not caught up with technology. These laws are like 50 years behind. They're lagging behind. However, there are creative ways that, survivors, can go into a court and say, stalking is a crime, right? Harassment is a crime, right? All of those things. And you can advocate for the survivor. You can be creative. You can talk to other attorneys who may have language that, can be placed on an order of protection, so that the survivor can have some sense of security around that. So you also want to talk about what comes with criminal, a criminal court process or a family court process, right? You want to talk about the length of time that it takes, right? And there may not be a possibility that some evidence may be admissible, right? Does someone have a question? What platform has irreversible blocking? I didn't realize that. No, there are no platforms that have reversible blocking. You can unblock a person, but then you'd have to friend them again, right? So if you try to friend them again, they'll know that they were blocked, right? So you can't reverse it. So we need to let survivors know that. So usually on phone or social media, I find it reversible. I see that. Yes. So on social media platforms, you can't, but on your cell phone, you can block and unblock someone, right? And usually how a person may know that they're blocked is that it goes straight to voicemail, right? But again, you want to talk that through with the survivor and then help them understand that, if it's going straight to voicemail, they may start leaving voicemails now, right? Or they may show up at your front door now, right? So you want to talk about that and how you can safety plan. So survivors may also want to change the settings in their device, right? Or their privacy and safety settings, right? So how many of us know that on certain platforms, you can have close friends? So you can limit who sees that you were having a good time in Atlantic City last weekend, right? Everybody doesn't have to see that, right? So your coworkers don't need to see your personal life. So you could just be posting about, excuse me, you could just be posting about your day-to-day for your coworkers to see, or about articles. And then, for your close friends, they can see, what you do on the weekend. Did we know that we have access to that? Those type of settings on platforms? As I take a sip of water. Yes, no? Most of these apps, can limit, the privacy, right? Your privacy. So you want to talk to survivors about that, right? You can still remain connected to that person. Maybe the survivor does not want to unfriend the abuser again, for whatever reason, and that's their choice, right? Because they're the ones that are leading the safety plan. So if that's what they decide, maybe you want to talk to them about how they can limit what they're sharing, right? And go through that. A lot of these apps, a lot of these popular platforms have privacy and security checkups, where you can go into the back end of the app, you can go into your settings and see who is seeing what, right? I will also send a follow-up link so that you all can see that. So are we good on that? On what does the survivor want? Right? Those are just, some of the things that we like to share. So we don't have a checklist, but that's what it is. So I mentioned a lot of this before. You want to find out who had access, what opportunity did the abuser have to gain that access, where does that information live? Does it live in Dropbox? Does it live on a hard drive? Does it live on social media? Does it live on the device? What about the child's device? Did the abuser gift the child a tablet, right? Does that information live on that tablet? You want to think about all of those different things, right? Does it live on a camera, on a phone, on a laptop, so on and so forth? So again, I'm repeating myself by saying this, but talk about all of the online spaces, not just major social media sites. Review all privacy and security settings, all of the devices that the survivor has access to, including whatever smart device they're connected to, all of their accounts, right? Find out what accounts. Have them create a list, If they're living with the abuser, they can't take that list home, right? But have them create a list while they're meeting with you, or you create that list. What accounts do you have access to? What accounts do you use daily? Where does that information live? And you want to go through that list, and then you want to say, that's where that information lives. That's how the abuser is gaining access to it. And then you want a safety plan around whatever that is, right? Does anyone have a question before we jump forward? Okay. For some platforms, if you unblock someone and try to block them again right away, the platform won't allow. That is so true, Catalina. Yep, absolutely. They'll give you a few more days before you can friend them again. Yep, absolutely. Because online harassment just doesn't happen with, intimate partner. It can happen, to anyone. If you're sharing an opinion online, right? And now, someone is attacking you. Maybe it's someone from high school or, someone that you know in common, right? So this is not just about intimate relationships. This can happen to anyone. So yes, thank you for sharing that tip. Yes, so document. It's so important that survivors document what is happening if it is safe to do so. Obviously, if they live with the abuser, you don't want them to be gathering that information. But you want that information to live somewhere. Maybe they have a chart in your office, right? And they can write down that on Tuesdays at 12 noon, this is when they're receiving those phone calls, right? Take screenshots. Screenshots are really important. Send those screenshots to an email that is not compromised. Take photographs, print out pages. Don't delete those emails, right? And preserve that information if that's something you would like to do. And recording options as well. Check out what state your state before you do that. Some states have, you have to get consent from the other party before you record. So make sure that the survivor is looking into that before they record. So that's a lot about, what you can gather. I want to jump into confidentiality really quick because I know that was something that was requested as well. We won't be able to do a deep dive, but I just wanted to talk about this really quick. In the chat, can you tell me why privacy is important to survivors? Why privacy is important to victims of domestic violence, sexual assault? Why is that important? Why is this important? Just drop some things in the chat. Why is this important? There's no right or wrong answers. No right or wrong answers. Just drop some stuff in the chat. All right. It seems like some of you have been to this training before. Okay. Good answers. And none of these are wrong. Yes. Thank you. Privacy, safety, trust, control, dignity. Oh my goodness. Have you all been to this training before? Maybe you could unmute yourself and help me present because you got them all right. So yes, this is so important. I want to shout out our partner, one of our consultants from the Confidentiality Institute, Alicia Aiken, who partners with us and helps us craft a lot of this content. If you ever have a technical assistance question, reach out to us and we can connect you with Alicia Aiken, and she knows her stuff. So it's really important that we keep this in mind. The way service providers do or do not respect the survivor's privacy can impact a victim's safety and their healing, because if we don't help them keep their information related to seeking our services private, it could mean danger, right? It could mean danger. It could put them at harm, right? It could influence the quality of life of a victim. It could impact the chances of re-victimization. And it's their information. And it may be the first time in a long time that they have had someone who actually honors that and gives them back that control, right? So it's really important that we keep that in mind. So thank you all for participating in that quick activity. All right, so FAWA FIPSA VOCA on confidentiality. So it says grantees shall protect confidentiality and privacy of persons receiving services. Grantees shall not disclose, reveal, or release any personally identifying information, right? Any personally identifying information. So let's jump into the law. I'm not an attorney, but the law says that grantees and sub-grantees shall not disclose, reveal, or release any personally identifying information, also known as PII, right? We cannot disclose any individual information collected in connection with program services. So even if the person requested services, utilized your services, requested the services, and they were then denied, we shall not disclose or reveal or release their information, right? So this covers the survivor that is receiving every service at your organization, as well as the survivor that you spoke with once on that phone that requested a referral to a food pantry or needed crisis counseling, and you never met them face to face. So even that one contact that you had with them over their phone, if that person receives some form of support from your agency, that is considered services. We good with that? All right. Okay, so to whom and what does this apply? confidentiality applies to all of the VAWA grant programs as a global condition. So anyone receiving this funding must comply with these obligations. And this applies to everyone who requests or receives victim services from a one of these funders, right, funded programs. So as service providers, we have to juggle multiple confidentiality obligations. And as recipients of these grants, it's important that we are all well-versed both in federal and state-specific obligations, while also keeping in mind that some service providers also have professional, ethical, and licensure obligations that intersect with the work that they do alongside others who work at these local programs. For example, attorneys and licensed social workers will have different obligations than advocates, right? So it's important to know them all and to make sure that survivors have a clear understanding as to how their information will be treated by these different roles within the organization. When I worked at a local program called Barrier Free Living as an advocate on a multidisciplinary team of social workers, occupational therapists, we had a part-time psychiatrist, and sometimes an attorney would pop in and out monthly to do a legal clinic. We had a really great team, and we were all working towards the same common goal of supporting the survivor. Everyone that was a part of that team had to clarify with clients how their confidential information was going to be managed within that organization, whether it was with colleagues who may provide coverage in my absence, within supervision and task force meetings, right, or any consultative relationship. Consultative relationship. Keep in mind that this does not apply to systems-based advocates. So advocates working with victims assistance programs or forensic nurses. I'm sorry, let me just get a cup of water. 1 second. Okay, so there's a lot to juggle while being on that team because there were so many service providers. So I had to be cautious and had to make sure that the survivor knew that we were all working towards that common goal of supporting them within the organization and that their information would not be shared beyond our program. Now that excludes the psychiatrist and the attorney because they did not work for Barrier Free Living, they were consultants. And unless the survivor requested that I speak to them, I did not share any information with those consultants. On top of that, many of the survivors that I worked with lived in supportive housing, assisted living facilities, shelters. Some survivors also had home attendants, on-site case managers, and doctors and housing assistants, right? Although those service providers were working toward the same goal of supporting the survivor, I could not disclose any information about that survivor unless the survivor requested it, right? And that had to be in writing. Can I get a thumbs up on that y'all are following me? Because I know I said a lot. Can I get a thumbs up that we're on the same page when we are talking about that? Cool, 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 cool. All right, so, oh, I skipped the slide. Oh, okay, so, and just to drive this point home, when I worked at Barrier Free Living's non-residential domestic violence program, if the survivor that I was working with was also a client and a resident at Barrier Free Living's shelter. So Barrier Free Living had a non-residential program where they could seek out services, and they also had a shelter called Freedom House. Although it's the same organization, I could not disclose any information about that survivor if I did not receive consent for that survivor. I couldn't talk to anybody at Freedom House about what I was doing with that survivor at the non-residential program. So privacy can literally be a life and death situation for survivors. This is why victim services organizations serving survivors of domestic violence, sexual assault, stalking, and trafficking have such strict confidentiality obligations, and breaches to this confidentiality are taken very seriously. It can literally ruin a program's credibility within the community. Imagine a survivor coming from a rural or an insular community or from any community opening up and sharing details about abuse, trauma history, and personal information with a service provider that they have built trust and rapport with, and then finding out that this information has gotten out to a third party, right? Imagine that I could imagine that survivor would be devastated. Not only can this deter the survivor from seeking further services at that organization, it also means that less survivors will find that this program is trustworthy, right? Enough to risk seeking services or assistance. So I just wanted to drive that point home. because it's so important that we keep this in mind, right? Their data does not belong to us. So now let's jump into choice. Let's talk about choice. Who decides what, when, and to whom information is shared? Oh. So choice. So it's important that we bring up the word choice, and especially when we're working with marginalized communities, we have to ask, what are options when you don't have a choice, right? I'm sure that we all can agree that, especially for those marginalized communities, immigrant communities, those people who have disabilities, those who identify as LGBTQ, for many Black and brown folks on the margins of the margins of the margins, right? There are often not many options given. So when they're walking into your office, you have the power, right? They don't know about choice. So it's important that we talk to them about this, right? I'm going to share an article with you all. It's called Trading Privacy for Survival. I think it's a really great article, but it talks about how, you know, survivors who come from marginalized communities oftentimes give up their data and their information freely because they need something from us, right? We have something that they need. So it's important that we recognize that power imbalance and we give survivors back that power so that they can exercise the same language when they're going into other agencies as well. We have to model for them. So this says privacy equals choice. So I, the survivor, have a right to decide who knows my information, and privacy is a right to me, and that every survivor who enters a program has that right. So when survivors make the choice to seek services, they're putting themselves at risk, and we have to honor and uphold their right to privacy. That means that they have a right to decide who knows their information and what specific information they want to share. I can recall various times receiving attitude and rude voicemails from caseworkers that worked for Child Protective Services because I wouldn't share client information with them. I didn't have any written consent to share that information from the survivor, so I couldn't disclose that information. So doesn't matter. I wasn't trying to be difficult, right? I was protecting that survivor's privacy. So it's really important that we keep that in mind. The survivor decides. The survivor decides, not us, because we find it convenient or because, you know, we want to gather that information quickly. This is what the law says. This is what the law says. So we have to honor that and respect survivors' privacy and their choice. So confidentiality. I, the advocate, have an obligation to protect the survivor's rights to decide who knows their information. That means that it is the program's job to protect the survivor's right to privacy. The program doesn't decide who can see the victim's information. The victim does. This privacy is the foundation to everything else. It's what makes seeking help worth the inherent risk, right? And it's easier to do so if they know that their information will be kept in the strictest confidence. Without that, there would be a major chilling effect on help-seeking behavior among survivors. They just wouldn't take the risk, right? Let's think about that small insular community where there's a tendency for everyone to know everyone's information, right? Then indirectly, how a person can be cut off, become homeless, lose supports or backlash and violence if anyone finds out that they're receiving services or share the experience of the family with you know, someone outside of the family, right? So it's really important that we keep that in mind. Please, please, please keep that in mind. So I'm gonna jump ahead. D is for data. We talked about data early, so I won't jump into that, but let's see what's inside of Cookie Monster's jar. In Cookie Monster's jar, we have names, phone numbers, date of birth, abuser name, history of abuse. These are just some of the things that we ask the survivors that we're working with, right? Data, whatever you want to call it, it's all information, right? And it's information that we are collecting. So more information required. Here is some more data that we may be requesting. Experiences of assaults, the mental health diagnosis, uncertainties about themselves, right? How they feel about the abuser, how they may feel about raising their children, right? How they cope, if they are self-medicating, right? We're gathering a lot of this, and some of this we don't even need to collect or write down, right? Heaven forbid there's a breach, right? Heaven forbid that, you know, something's written down, and let's say that you wrote it. Back when I was doing advocacy, we had paper files. I know a lot of stuff is electronic, but heaven forbid I took that file and left it on a bench, right, while I was having lunch, right? All of that information is left in that file survivors' data about their address, where they live, all of the case notes, all of that information. Same thing goes for information that's stored in our databases, our electronic databases. Who has access to that information? How long is it stored in that database, right? Can the survivor have access to it? You want to talk about all of those different things. Why are we collecting information about survivors' tax exemption status from 2009? Is that information that you need to keep? Why is that on the intake form? These are things that we need to talk about. I know that many of us may not be decision makers, but it's something that we need to talk about, because the more information that you collect, the more risk you could be putting a survivor in. Do we need that information? No, we may not even need that information, right? So it's really important that we keep that in mind. Who wants this information? People want this information, right? For example, the abuser, anyone connected to that abuser. Abusers generally want it to cause harm, and they will go to great lengths to get it, and they will hire or recruit others to help them, right? This may include attorneys, family members, investigators, friends. Who else? Law enforcement, courts, prosecutors, judges. They may want that information for an open case, to corroborate facts or to discredit a survivor, right? Child welfare agencies, they may be looking for information on whether the survivor is a fit parent, right? And if you wrote down in a case note or something that, the parent doesn't like, survivor doesn't like being a parent, and, struggles every day, with the child, that's data and information that people want to see, right? So that they can cause harm to the survivor, so that they can discredit the survivor's parenting skills and capabilities. So it's important that we keep that in mind. Also the media, right? Media may want this information. Let's say that an incident occurred in or near the shelter, right? And the incident happened and the media finds out that the survivor was receiving services at your program. They will want to know that history, right? And if by any chance if that information is leaked, that can impact the survivor in a negative way. So it's important that we protect this data. Any questions around that? We're about to wrap. Any questions around that? I know that I'm preaching to the choir. You all know this. But I just want to drive this point home, because there are in many spaces where, we're so overwhelmed and we have so many different things that we have to do. We're managing such a heavy caseload, and in order to get things done, sometimes we may overlook some of these policies. So any questions around that? Okay, so no. All right, so here's a great visual. It's a simple visual. I think it's our last slide. So inside the circle, the survivor chooses to share information with staff of a victim services program. So that's you all that work within that specific victim services program, right? Outside of that circle, we have law enforcement, child welfare, other victim services programs, other service programs, your funders, auditors, allies, right? Those are the people outside of the circle, right? So staff at that agency have to protect the information that the survivor has shared with them. The program can share that information with anyone within that program if it is something that is done with the goal of helping the survivor achieve their goals. Anyone outside of that circle cannot receive information about a survivor. Anyone outside of that circle cannot receive information about a survivor without an informed, written, and reasonably time-limited release. This includes law enforcement, child welfare workers, other victim services programs. And that release must only be sought because the survivor wants their information shared. It cannot be a requirement to receive services. I will share more information around that. I know that we are short for time. I want to pause and gather, see if there are any questions. So really quickly, the best practice is less is best. The less you collect, the less privacy and safety risks for survivors. Less equals less information and less details, right? So you don't want to write down details. You don't want to collect any information that is not helping you to reach the goal that the survivor initially came to the organization for, right? So you don't want to collect data and information that's not needed. Here are some of the toolkits that we have on our website, techsafety.org. I will send a follow-up email tomorrow to Miranda and Annette so that they can get this information to you all. Some of the links that I mentioned, I will send those to you all, but we have so many different toolkits for survivors, legal systems. We have an app safety center, agency use toolkit, confidentiality toolkit, digital services toolkit, and they're easy to read handouts. If you have any questions, you can always reach out to us. We also have an app. It's an informational app. It's everything that we discussed towards the first portion of this presentation. It talks about how, technologies are misused, safety planning, location safety, all of the things that we discussed. It's also available on the desktop as well. We also have an evidence collection app called DocuSafe. Thank you to our funder for keeping this going. This is an evidence collection app that survivors can use if it is safe to do so. We don't want survivors downloading any apps on their device if their device is being monitored. If their apps are being monitored, we don't want them to download any of this, but it's something that you all can download to familiarize yourself with. And that is the end of the presentation. Are there any questions? I'm sorry that I had to rush through that. Again, this could be a full day conference that we have around these topics. So if you have any questions, please let me know. You can unmute yourself and we can chat. You all will also get a copy of the presentation. Please just keep in mind not to share it outside of your network. Don't post it online because we want to make sure that people are not being informed on how they can misuse technology. So keep this information within your network. If you have any questions, feel free to reach out to us. We provide technical assistance. Reach out to us at safetynet@nnedv.org. We are here to help. Thank you all. Thank you. Thank you. And thank you for your participation. Thank you for having a sense of humor. I know it's the end of the day, so I'm glad that you all, stuck around. Miranda, Annette, is there anything else that you all want to mention?
Nope, that's about it. Thank you so much for your time. That really was an excellent presentation and really, really interesting.
Awesome.
Everybody, thank you for attending another day of NGO. We will be back at it again tomorrow for our final day of the week. Get excited. And then, of course, there will be some office-wide sessions later in the month and into January. Again, just look at your emails for more details about that, and I'll remind you again tomorrow. But other than that, you can log up an extra 8 minutes early for the evening. If you have any questions, feel free to stick around, but otherwise, we'll see you in the morning. Thanks, everyone.
Thank you. Bye, everyone.